Good morning, Ms. Tsengani.
Good morning, Chief Justice.
Tsengani Mbakaza.
Yes, Chief Justice.
Are you well?
Chief Justice, I'm fine. Thanks for asking. I hope you are also well.
I am, and I want to think that the rest of the commissioners are too. No one has complained.
Yes.
Are you ready for your interview? As ready as can be?
I am, Chief Justice.
Okay, all right. Just forgive me, I have just too many papers in front of me. And there are too many submissions on your division. I don't know why that is. You are a fellow alumnus. You studied at the University of Transkei,
That's correct, Chief Justice.
where you obtained a BUris and LLB degrees.
Yes, certainly.
All right. Your career has been concentrated in the Department of Justice. You started out as, you did not prosecute, did you?
I did, Chief
You
Justice.
did. For how long?
Yes.
Since, for how long?
Chief Justice, I started prosecuting on a voluntary basis immediately after I left school. I was appointed
In 1999?
Yes. Yes. I was appointed at Zwelicha Magistrates Court for a few months. Thereafter, I was appointed as an aspirant prosecutor. From there, I was appointed on a permanent basis as a public prosecutor. And that was in Butterworth.
And you remained there until the end of towards the end of 2003?
No. I applied for a position of a state advocate in Witwatersrand, as it then was. Then I applied for a transfer to Makhanda, where I remained as a state advocate. Then around 2006, 1st October, it's then that I started to assume my duties as a judicial officer. Yes.
In Vicksburg and
In
Rosendal periodical courts?
Vicksburg, yes, Rosendal periodical courts as well.
All right, and you've been a magistrate. You've worked your way through the ranks of the magistrates since that time. And which position do you hold now?
I'm holding a position of a regional magistrate in Zwelicha, Eastern Cape.
You were a senior magistrate for a spell, and before you became a regional magistrate.
That's correct.
I remember you when you were in Bloemfontein. What were you doing there?
Bloemfontein was our main office, Chief Justice. I remember I was working in Vicksburg as a magistrate. From there, I was appointed as a senior magistrate. So sometimes we would attend meetings in Bloemfontein. Yes.
You have been a magistrate for how many years?
For almost 20 years, almost Chief 20 Justice.
Years, yeah. Yes. It's a long time.
Yes.
And during these 2 decades, what kind of work have you covered? I would imagine a healthy mix of
a variety,
criminal and civil.
Yes, a variety of work, Chief Justice. When I was appointed as a magistrate in Vicksburg, I realized that everything was confined on criminal work. And then I started to have my own individual development plan that I discussed with the chief magistrate that I would like to be exposed to civil work. And then I attended a course that took 3 weeks under the auspice of Sajay. From there, I practiced both criminal work and civil work. And because I was a senior magistrate and a head of office, I had no option than to practice more of civil work, because in those days, there was this perception that if you're a senior magistrate, then you have to do everything, especially civil work and family work.
You have had the opportunity of acting as a judge for, what, 61 weeks?
It's more than that now, Chief Justice. It's over 70 weeks. Yes.
Where? In which division?
Eastern
Well, in
Cape
which
Division, Mthatha, Ugombo, Makhanda, and I had an opportunity to do oppose motion in Gqeberha.
All right. I'm still trying to get used to the name Ugombo. I know Emonti since I was for 60 years now, that I've been on more than 60 years I've been on this app. So it's going to take me a while, Premier, to get used to this new
Yes, yes, Chief
moniker.
Justice. I also don't want to offend anyone. I'm trying to be used to it. It's Ugombo.
Indeed, it is. All right. What kind of work have you done? What kind of cases have you adjudicated during your acting stints, your many acting stints?
During my acting stint, Chief Justice, I've been exposed on a number of occasions on motion court proceedings, doing all sorts of applications. I've done a lot of criminal appeals, civil appeals, the full bench, and in some instances, the full court. Those cases involve, amongst others, the delict, foreclosures, all sorts of applications that you can think of. Mandaman Fence Poli, Raven Dicatio. I can count a lot, Chief
The
Justice.
spectrum.
Yes.
Have you written judgments? I know
Yes.
that you have attached a few. How many do you think you've written?
In the High Court, Chief Justice.
Yes, in the High Court.
Over 90. I've physically counted 93 judgments.
Any of them reported?
4 judgments are reported. Yes.
That's something. You did write it. We seldom see judgments written by magistrates. Did you write as a magistrate?
I did, Chief Justice, especially with civil work. With civil work, you have to write and hand down judgments. It became worse after the COVID era. So we had to write and email some of the judgments. So I did write a lot of judgments. The only discipline where I would just deliver extempore is criminal work. Yes.
Yeah. All right. Any of those civil judgments are decent enough that you would share with someone else?
Come again, Chief Justice?
Any of the civil judgments you wrote as a magistrate of a substantive nature, I mean, well, how were they? Would you proudly share them?
Yes, mostly it was divorce matters and your ordinary unlawful arrest and detention, a lot of those.
But they were considered judgments.
Yes.
Okay. You have held a number of leadership positions as a judicial officer. You were a national secretary of Jawasa and ARSA until recently, and I'm just trying to link up your CV is scattered. You were a provincial secretary of Jawasa for about 4 years.
Yes.
For a term, and then became a national secretary.
That is correct.
Until 2022.
That is correct, Chief
All
Justice.
right. And for a while, you were joint secretary of the two bodies.
Of both organizations, yes.
How did that work?
It worked perfectly, Chief Justice, because we have issues of common interest. That is between Aramsa and Juasa. And I was elected, I had to heed to the request of the membership and continue to whatever they were confident that I will do.
And you've been, of course, a very active member of the South African chapter of the International Association of Women Judges since the early
Since-
2010s. Yeah.
Yes.
I know your work there.
Yes.
You have a course in independent mediation. What it's a what is
Mediation.
it? It's a mediation certificate.
Yes.
When did you do that?
That course is the course that I got when I was at the University of Transkei, as it then was. And our lecturer was Professor Samela, as he then was. So it was just for a few days, but it was an interesting course.
All right. Have you had an opportunity to apply it, those
Bo-
skills in your work?
Yes, both professionally and personally, Chief Justice.
The one of the professional bodies, as you know, comment on candidates, and I think it's the GCB
Yes.
that has raised a couple of concerns about your candidature. They make the comment that your experience is limited to what they call state appointments, and that you have no experience either as an attorney or an advocate. And I want to ask you if that should disqualify
Yes,
a
Chief
candidate
Justice.
for judicial appointment. Well, you are a judicial officer already. I mean, a magistrate to becoming a judge.
Yes, Chief Justice, I've seen that comment, but it should be considered that I've grown in the profession. As already noted, before I embarked on civil work, I started to have my own plan to say I want now to focus on civil work, which I did in Mthatha when I was a senior magistrate. From there, I practiced civil work in the regional court. The records of the High Court, in particular the judgments that I've written in civil proceedings, speak for themselves because I believe in transparency. All my work is published on SAFLI.
Well, more concerning is their comment that some of your judgments showed poor linguistic style and were littered with typos, which is a no-no in court judgments. Have you spruced up? Well, first, is this criticism correct? And if it is, have you spruced up on these shortcomings?
I note the criticism, Chief Justice, and I accept it. However, I want to place on record that when they made comments about me, it transpired that at some point they made a mistake. For instance, they referred to a certain judgment, Telok Waste Management versus Nelson Mandela Bay Municipality and others. And they made some adverse remarks insofar as that judgment is concerned. I brought this to the attention of the Secretariat. Actually, I just wanted clarity because I could not recognize this judgment, excuse me, that they were talking about. And they tendered an apology to say they actually were referring to another candidate and they made a mistake. So I accepted the tender. That is now the apology.
Well, unfortunately, that was, at least I don't have it in my papers. That was
Yes.
not brought to the JSC's attention. It happened between you.
Yes,
which
there is
is
a
most
letter.
unfortunate. But I'm not blaming you. It's not your fault. I'm not blaming you for that.
Yes, yes, if I may just place it on record, Chief Justice, that the letter is right in front of me, the letter that they wrote indicating that they made a mistake.
All right. No, thanks for that. All right. I'm going to hand over to our objections committee. There is an objection, or one I think, that was lodged against your candidature. So they will deal with that.
Yes.
Thank you, Chief Justice. Good morning. I have read the objections and your responses, I can't speak for the Objections Committee. I'm just assisting because many of their members are not here this morning.
Yes.
But I've also received a comment from the committee itself in relation to the many and vociferous complaints lodged by your previous or your former husband. The Objections Committee decided that this is not something that should be taken up with you in this public forum. And their reasons for that was that none of the official bodies before whom these various disputes have played out have actually supported them or found a factual basis for them. And so, for instance, the Director of Public Prosecutions has declined to prosecute, and you've produced evidence of your tax compliance record.
Yes.
For my part, having read your response, I must congratulate you on what is a very measured and thorough response under very, very stressful circumstances. And speaking as a woman in this public forum, the way in which you have single-handedly brought up 4 children and they're all being educated without any assistance is absolutely commendable. So I just wanted to make that known. In relation to one other matter, the GCB draws attention to the fact that you yourself list 6 reserved judgments. And
Yes.
I note that those are all matters that you dealt with during 2025, so they're not long outstanding. You've produced a list that indicates you've now given all those judgments. So we've taken note of that. There are a couple of dates that are erroneous in your list, and that's my only small little quibble about everything else you've done extremely well. So I think, Chief Justice, that's enough from me.
Thank you very much, Commissioner Kay. I'm going to hand over to the commissioners to put questions to you. And before we do that, I want to quickly welcome Acting Judge President Tlangulela from the division you want to join, and the Eastern Cape Premier Mabuyane. I forgot to acknowledge you because you were late. You kept us waiting. So you owe us an apology. But perhaps now that I forgot to welcome you timelessly, we even. We'll call it even. You don't have to apologize. AJP, do you have questions for this candidate?
Chief Justice, just a general question.
Go ahead.
Just one general question. What is your feel, not a gut feeling, based on the activities, your activities as an acting judge in the Eastern Cape Division? What is your feel?
Can you come again,
What
AJP?
is your feel? Do you feel that you are part of that community? You are not part of that community? And if you are, can you, in a summary manner, tell how you feel as a part of that Eastern Cape Division community?
Yes. Thank you, AJP, for that question. I was invited to act in 2023, and the first thing that I felt was a positive start is when we were orientated to the High Court settings. We were accustomed to the code of conduct, the norms and standards, the conventions of the division. It has been a very enjoyable journey. Of course, if it was food, I would say sweet and sour, because there will be instances where I would feel that the workload is higher than what we have in the lower court. Chief Justice and the commissioners, I want to mention this, that we always talk about transformation, and I feel that this was not just an invitation for the sake of inviting a candidate to come and act in the High Court. it was transformation in the true sense of the word, because even though you would be appointed for Makhanda, for instance, you would be given an opportunity to go to other divisions, the ones that have already counted, Mthatha, Kugombo, and Makhanda. So in those areas, you will be exposed to quite a number of disciplines because there's variety of work. So I really enjoyed working in the High Court. I feel that it's an opportunity for one to grow and take the judiciary to greater heights. I must also state that the assistance from the senior judges was very exciting. They would physically assist me where I cannot be in a position to traverse. And even emotionally, you don't feel isolated. And I just want to place it on record that I really thank that opportunity. Thank you, Chief Justice.
The last question. Having said that, you have been exposed to working at all the stations of the Eastern Cape Division. If appointed, where exactly do you think you would make a contribution the most? I have here Makhanda because there are 2 vacancies for Makhanda and 1 is in Mthatha.
All right. Thank you, AJP.
Well, before the candidate answered that question, AJP, I always thought that your judges, the judges of the division, rotate on an equal basis among all the seats.
That's correct. That's what we
So I just have a bit of a difficulty with that kind of question in light of that arrangement. You are not a judge of Makhanda, you are a judge of the entire division. But if
I appreciate you. No.
no, you
Withdraw
can
the
carry
question
on.
if it's not going to contribute meaningfully to the discussion.
I don't know what's behind.
I withdraw that
I don't know
question.
what underlies your question.
No.
Maybe there's something you want to bring out.
No.
Okay.
That's fine. I withdraw that question.
Thank you, AJP. No further questions?
I have no further questions. Thank you very much, Honorable Chief Justice.
All right, thank you. Premier, do you have questions for the candidate?
Not really, Chief Justice. Good morning to all commissioners. Let's apologize, but we were here 30 minutes, but we were in a hidden place.
Yeah, we did hear about this
We
hidden
sincerely
place.
apologize. No, not much. Just probably just trying to attempt further the question which was raised by Acting Judge President. That, just to get a sense, what value do you think that you will be able to contribute to our division? Also, what's your understanding on the state of the judiciary in the Eastern Cape? What could be the challenges that you think are really teething, probably need someone like you coming on board?
All right. Thank you, Premier, and thank you, commissioners. Commissioners, I think I've already added value in the judiciary in the Eastern Cape, and it is my wish to continue to take the judiciary of the Eastern Cape in greater heights. As I have already indicated, with my skills that I've acquired through my experience, I've at least demonstrated that I am able to navigate both in public and private law. So in other words, this to me is a huge contribution. And another contribution is the development of jurisprudence, Premier. I've demonstrated through the judgments, especially those that are reported, that I can contribute towards the development of our jurisprudence. Insofar as challenges are concerned, there were so many challenges raised regarding the Mthatha High Court. I've worked in that court on a number of occasions, despite the fact that I spent most of my time in the courtroom. At least I am able to identify some of the challenges, especially those that can be resolved there and then. For example, the loss of files. I was there on the last week of the first term doing motion court. Out of 168 matters that I had on the roll, we only did a lousy 38 matters using a conventional method. In other words, the e-justice system is working perfectly. Therefore, in my view, the loss of files and the loss of court orders is going to be something of the past. And I've seen a lot of cooperation with the litigants, and especially with regards to this e-justice system. And that concludes my presentation in this regard.
Thank you, Premier. Is there follow-up? All right. Minister.
Thank you very much, CJ. Good morning to you. Good morning, Commissioner. Good morning, Ms. Mkengani Mbakaza. I'm calling it correctly.
Good morning, Minister.
I took interest in one of your judgments, the work that you have done in terms of a minor that was raped.
Yes.
And particularly my interest is looking at the time of the incident and the time that the judgment has been delivered.
Yeah.
Maybe if you can share, because I normally get into trouble when I go to Parliament in terms of the turnaround time of child justice, how we handle the cases in relation to this. And many of the magistrates have reported that it's because of the complexity of the matter. How did you manage to get it within this short space of time and with one witness in terms of the process that you've handled?
On which page is that judgment, if I may just be assisted?
Page 48.
Page 28.
It relates to an 11-year-old daughter of a complainant.
I have a different page 28. May I be assisted?
I think even in terms of the comments of AFT, they've summarized it on their summary as case judgment of, I don't know, see the page here, but I think it's number 7, where you are the sole author. It was issued on the 27th of March.
So the judgment was handed down on the 27th
27th of March 2025.
All right, Minister. It was heard on 24, 25, and 26, and then it was delivered on the 27th of March. Minister, if you may assist me, what is your concern?
It's not a concern. I'm asking, how did you manage to get it within a short space of time, looking at the matter, because you had one person who was testifying, which is the minor.
Yes.
You were able to even order the separate, so you followed the procedure correctly. And I'm saying, how did you get it right? Because it's one of the difficulties in dealing with gender-based violence, where we don't seem to have judgments, processes being done quickly, and also judgment be issued quickly. So I wanted to understand, what is it that you put in place that helped to be able to get this process done? Because the complaint was on 2024, and we were able to see the judgment towards the end of 2024. You were able to hear the matter in 2025 and issue a judgment in the 27th of March.
A day after the closing argument.
The closing argument, yes.
Yes. A
I
minister,
understand it has not been challenged.
no, it has not been challenged. Minister, everything works perfectly if you have a strategic planning. And in my case, I'm very committed to my work. I like my job because I don't have anything else to do. My work, my life is like a triangle. It's from home to work, to the shop, and back home. So that works perfectly for me. More also, I developed a strategy that I must make it a point that I at least work 11 hours a day, and my system is used to that for 6 days a week. And then I do errands and look after my kids on a Saturday. So in order for you to be in a position to deliver judgment expeditiously, you have to have experience of these things. Remember, I've been a regional magistrate for almost 10 years. I've been handling sexual offenses matters in the Eastern Cape for a very long time. So some of the legal issues, in particular, the legislature and case law, is running in my veins. Therefore, what I do before I go to court, I look at the indictment, prepare whatever I want to prepare, note whatever I want to note as a concern before the trial starts. And one other thing that I do, before I navigate or I start a trial, I hold a mini meeting with the parties, informing them that I'm a visitor in the High Court. I'm not here permanently. I cannot pick up a part head here. Please, if you are not ready to proceed with this trial, indicate now so that we iron out those blockages before we start a matter. So that's what works perfectly for me in almost all the cases that I handle in the High Court and the Regional Court. Thank you, Minister.
So when you are permanent, you are going to leave, you can have the time. I'm worried about that part.
When I'm permanent,
Because I'm commenting you for the turnaround time, especially on gender-based violence and especially that deals with minors.
Yes.
Because the complaints I receive, for example, if I visit communities, is that it's almost like a child grows going through testimony. One incident the child had was 8 when they were raped, and they're still going through trial at the age of 12. So I'm saying, when you make the comment that currently, because you are acting, you tell them that you only have short time. So my worry is that if we appoint you, you're not going to tell them that you have short time. So it means these cases will go for longer. That's my concern I have.
no, that's not what is within my system, Minister. I wouldn't sleep if I have cases that are hanging. I make it a point that all the cases that I deal with, and I'm known for that, I deliver them timelessly.
Okay, just a follow-up last one, CJ. In your CV, you've reflected that you are experienced in administrative law,
Yes.
specifically Paja and Paya. Now, with regards to Paja, litigants have a limited time that they generally must file their judicial review within 180 days of the decision or after exhausting internal remedies. Now, if this deadline is missed, a formal condemnation application is required, which the court can only grant if it is in the interest of justice. Now, do you think this limited time is a barrier or can become a barrier for less people who have less resources in terms of accessing justice, especially where they should be able to file their documents within this limited time frame?
Yes, the time it may be limited, and one may argue that it may be it's limited. However, there are remedies applicable. It's not the end of the world. It doesn't mean if you have not complied with the 180 days, then end of the story. No. As you have indicated, Minister, you can still apply for condonation and on good cause shown. I've seen a lot of matters where that condonation is granted in the interest of justice.
Thank you.
Thank you, Minister. JP Tlaletse.
Thank you, Chief Justice, and good morning, Mr. Kangani Mbokasa. Do I have it right?
Good morning, Commissioner. Yes, it's Tengani Mbagaza. Thank you.
Kangani Mbokasa. Thank you. Yeah, just one thing on the GCB comment.
Yes.
At paragraph 6.3, they indicate that you lack an understanding of certain aspects of procedural law. And they refer to an instances in your motion court proceedings where you do not grant cost orders on attained client in default judgments, despite the fact that there was an agreement between the parties for that to be granted. And they take it further that you always say you've got a discretion whether to grant those costs or not, but you don't provide the factual metrics why in the exercise of that discretion. Would you like to comment on that?
I would like to comment on this. Thank you very much for bringing that up, Commissioner. They are specific in their criticism to say, for instance, in February 2026, I was at Gqeberha and this is where this happened. I wish to place it on record that I didn't want to take this as an issue, although I knew that I was not in Gqeberha in February 2026. So that criticism is not directed to me. However, assuming that it was directed to me for argument's sake, I would comment as follows if it was directed to me, that of course, the issue of course is a discretion of the court. However, the court has a duty to state reasons why a particular order is not granted. So I would say they are quite correct to raise a comment that no reasons were furnished. At least one must furnish reasons. But as I've already indicated, that's not directed to me. They have made a lot of mistakes, of which some they have accepted.
Yeah.
And
It's
not
either,
correct because
it's you or not. I mean, you cannot say it's in the event that is directed to me, therefore I will say, in the alternative. It's either it refers to you or not. So your answer here is that this is a mistake, it's not directed to you.
Yes.
It's about a specific instance. But are you saying there are no cases which have you ever been on the motion court roll? Did motion court cases?
A lot, yes,
lot.
Commissioner, yes.
Okay, in your approach to cost, there's never been instances where you refused to grant costs on attained client scale where there was an agreement between the parties to that effect?
Not at all. Where there's an agreement in terms of the contract, I would not. I never had a case like that.
I see.
Yes.
Okay, then the second thing, your case that you have attached is Uzile Mbalani versus Ntombonzi Mbalani and others. At paragraph, just a second, you refer to the Plascon at events rule at paragraph 19, while it started paragraph 18. Are you familiar with the facts of the case?
I'm familiar, we can go ahead.
Yes, you do say in motion proceedings, you can resolve the dispute of facts by applying the Plascon events rules. And then you say, again, the application of the Plascon events rule may in some instances, as in the present case, not be satisfactory. Why would you say it was not applicable in this case?
There are instances, Commissioner, especially in agent applications and the matter that I was dealing with, wherein you'd have to apply a robust approach, which I did in this particular matter.
A robust approach.
Yes,
What did the case involve? You had to decide whether there is a customary union or marriage between the parties or not.
yes, it was amongst the things that were raised. But the crux of the matter was that the applicant felt that the deceased ought to have been buried at his home because he felt that he believed that he was married, and he believed also that that was the wish of the deceased, which was, according to me, not the position, because when I read the papers, I came to a conclusion that the only wish that has been demonstrated in the papers filed is that of the applicant and not the deceased.
But I thought.
But because I wanted to resolve the issue promptly, I decided to handle it in that approach and make a decision there and then to say the deceased must remain where he is.
Yeah, but I mean, at paragraph 18, you say to arrive at this a decision, you have to make a finding as to whether the customary marriage existed or not.
Yes.
Yes.
I take note of that, Commissioner, and I cannot take this point any further.
No, you might be right. You see, I'm trying to establish that, if you rigidly apply certain rules, like in this instance, and the robust approach, you may declare an existence of something that does not exist. You may say with a robust approach, there's no customary marriage, and might have far-reaching consequences. Or you may say it exists, whereas it does not exist. So there could be a proper way of establishing that kind of a problem.
If I remember well, I relied on the confirmatory affidavits that were filed by other parties in confirming the applicant's case in that matter. But at this point, it's very difficult for me.
I see.
Yes.
Yes. And then just one thing, you've been a member of JOASA.
That's correct.
Judicial what is that? Judicial Association of say that?
Judicial Officers Association of South Africa.
Yes, and you have held leadership positions at high level.
Yes.
Yes.
Commissioner.
Yeah. I have seen media reports and statements made by some JOASA members that they go on go-slows, they are going to boycott and whatever. Ethically, do you have anything to say on that, of a conduct of a judicial officer?
Just like any other organization, Commissioner, the executive changes from time to time. When that resolution was taken, I was no longer a member of JOASA. When a resolution to picket, in fact, when the proposition to picket was made, that is at the time I was still a member, an executive member, I opposed that vehemently, and I succeeded together with other colleagues. So when this picketing was taking place, I was no longer a member, an executive member of JOASA, and we were divided, unfortunately, into two cliques. Some were saying yes, some were saying this is unethical. So in my considered opinion, I still stand by what I proposed initially, that we should refrain. And in fact, I don't think our code of conduct allows this. We should refrain from picketing. There are so many ways of resolving disputes.
But the message is in that as a judicial officer, you must carefully reflect before you join an organization, because you might bind by collective decisions of that organization, which might be wrong or against your code of conduct.
I've learned that. Thank you very much, Commissioner.
And you accept that picketing and going on go-slows is quite unprofessional on the part of a judicial officer.
No, it's a no, Commissioner, and I still stand by what I indicated in the executive of JUAS
Yes.
when
Thank
I
you.
was a national secretary.
Yes, just one aspect, with your permission, Chief Justice. The impression I got from you is that Eastern Cape High Court at all levels is a well-oiled machine. There are no challenges, no problems.
As far as I'm concerned, Commissioner, the challenges that I was talking about are those challenges that I experienced. I'm talking about loss of files and all of that, but I indicated that it looks like we are going to improve insofar as that is concerned, because everybody is excited with the e-justice system and they are uploading their cases. So I was saying there may be challenges, however, it looks like there's a room for improvement.
I see. Because from your bittersweet example, you did say that bitter was there was more work. Is that not what the judicial officer should expect, to get work and to adjudicate cases?
Yes, I was actually saying, compared to the lower court, the high court has volumes. So in other words, you have to devote your energy 100% to the work. I wasn't complaining. I was just
I see.
saying there's that transition that you must be used to, which according to me is a bit sour because you have to be in that transition.
Yes, having been involved at both sides
Exactly.
and levels.
Yes.
There is this whole thing that claim that there's no difference between the work in the high court and the lower court. We are all judicial officers who are doing the same thing, even more and more complex matters in the lower courts. What is your view on that?
I don't agree. And the reason I don't agree is because I have experienced the high court volumes, the high court work, the complexity thereof. I have acted for over 70 weeks, and there are instances where I would not sleep trying to think, how do I resolve a particular matter? So there's a huge difference in my view.
And you're saying this without prejudice to your relationship with your colleagues in the lower courts, I suppose. Thank you, CJ.
Thank you, JP. I just want to remind commissioners that there's a limit to the number of questions we may ask. You know what that limit is. No more than 2 questions, no preambles, no follow-ups. But I indulged the JP for a particular reason, because he is in this business and his questions I would have asked later myself. So he saved me time. Right, commissioners, I don't want us to fight. Chairperson?
No, thank you very much, CJ. Good morning, Ms. Tengani Mbagaza.
Good morning, Commissioner.
Ms. Tengani Mbagaza, I'm glad that you've been serving in the province of Eastern Cape and also appreciate your understanding of it as a deeply rural province. My question is regarding access to justice. What initiatives would you put in place to improve access to justice for the marginalized communities of Eastern Cape?
Access to justice starts with dealing with cases promptly, delivering judgments optimally and expeditiously. That's exactly what I've put in place, and that is exactly what I am doing currently. And another issue is the issue that I've already raised, namely the e-justice system, where I indicated that it looks like everybody is excited with this e-justice system, and therefore those that are represented are in a better position to have their cases uploaded. You don't really get unrepresented litigants in the High Court. That is why I'm highlighting this as one of the instruments that are assisting us in accessing justice.
No, thank you very much for the response. Now, taking from the last statement you made with regards to representation, obviously, by and large, the community there is grant dependent and they are indigenous by nature. In your view, how do you think that the legal system can be improved so that it can better service those that are in need?
I think a lot of strides have been done, Commissioner. For instance, we have what we call Legal Aid South Africa. And I've seen that a lot of practitioners at Legal Aid are very committed in their work. So those that cannot afford, they approach Legal Aid even for civil matters. So I think that is of great assistance. Thank you, Commissioner.
So you're happy in the manner in which they are doing their business,
Very
insofar as assisting the communities?
Very much happy.
Okay.
Yes.
No, thank you very much, CJ.
Thank you, Chairperson. Any further questions, Commissioners? Prof, followed by Commissioner Mangena.
Thank you, CJ. Good morning, Ms. Tengane Mbakaza.
Good morning, Commissioner.
I see that you have acted for over 70 weeks. My question is, what is that one thing as a magistrate that has helped you to navigate being the judge of the High Court?
It's curiosity, Commissioner. I'm very curious insofar as the development of legal issues are concerned. I have developed myself in terms of improving my research skills, and I have made a lot of commitment that caused some members of the legal profession to identify or to see that there's something, there are capabilities from this magistrate. For instance, I was informed that the reason why I was invited in the High Court is because of a particular judgment that I wrote in the regional court. So once you devote your energy and you show commitment, it is of great assistance.
Can you take us briefly to that judgment that made people to think that you have it to be an acting judge of the High Court?
No, it was just a simple judgment of unlawful arrest and detention. I don't remember the facts quite clearly now, but what is most important about my statement in this regard is that it was seen that this magistrate, when she writes a judgment, she devotes her energy, she applies the law, whether right or wrong, and then she comes to a conclusion.
That takes me to my second question. Please take us through your process of judgment writing. What informs that judgment writing?
What informs judgment writing is firstly, listening to the facts. You must be a good listener, because once you conflate facts, then it becomes a mess. Listen to the facts, identify the issues, very important. And then identify the law that is applicable to those issues. Apply that particular law, make your own reasoning, and come to a conclusion. That's what I do.
Thank you. Thank you, CJ.
You're welcome.
Commissioner Mangena.
Thank you, CJ. Good morning, Ms. Tengane Mbakaza.
Good morning, Commissioner.
JP Tlaletsi covered me regarding most of the questions, more especially on the aspect of cost. But I want to go back to that judgment of Mbalane.
Yes.
As I understand it, that matter involved family members
That is correct.
And the dispute was about who had the right to bury.
That's correct, Commissioner.
And in paragraph 9 of that judgment, you aptly states that the issues involved go beyond legal dispute. It involves family. Right?
Yes.
Now, it involving family members, and I would assume it would be between parents to the deceased. How come then that ultimately you exercise your discretion to award a cost order against the applicant? How did you exercise your discretion then?
I'm trying to think now because there was also an issue regarding agency, if you remember. And the general rule is that a successful party is entitled to costs. So I couldn't see the reason why I should deviate from that principle, given the few adverse findings that I made against the applicant, namely, first of all, that he was trying to pursue his wishes instead of pursuing the deceased wishes. That is insofar as I can take it, Commissioner.
No. Let's explore it further. You agreed with the applicant that he was justified to come to court on an urgent basis. So, agency-wise, you found in the applicant's favor.
Yes.
And then you went into the merits of the case. Now, and then you dismissed the application. So you can't use agency as a reason to penalize the applicant because you found in his favor.
Okay.
So the issue for me now is the exercise of the judicial discretion. And I'm putting this question to you because the GCB says that you've got some difficulty in understanding costs.
Commissioner, I have clarified that the criticism was not directed to me, but you are quite correct for asking me about Mbalane because that case was authored by myself. All right, let me correct myself to say, at the end of the day, the applicant was not successful. So I took a default position. And that is insofar as I can take it.
Thank you, CJ.
Thank you, Commissioner. Commissioner Trolley.
Thank you, Chief Justice. Good morning, Ms. Tengan Bagaza.
Good morning, Commissioner.
Bagaza, sorry. Judge Musaneke Commission found that there should be a relocation of the seat of the High Court from Makhanda to Bishu. It's been controversial and it has been opposed on 4 previous occasions. You've worked in all the divisions in the Eastern Cape. What is your position on that, seeing that you've also worked in Makhanda?
Let me preface that question by saying I've been working in rural courts throughout my life, mostly. And I know the hardship that are experienced by people that stay in rural areas. I am of the view that relocation of the seat is a good idea because, in my respectful view, it may enhance access to justice. And this issue of people traveling all the way from Queenstown to Grahamstown to access justice is, in my view, not the right thing. Thank you, Commissioner.
Thank you, Chief Justice.
Please, Wendy.
Thank you very much, CJ. Ms. Tengani Mbalazi. In fact, it could have been a follow-up on the question that was raised by the commissioner regarding the Mbalane case. You were asked on costs, and then you said that the principle that you applied is that a successful party is entitled to cost. Is that correct?
Yes, I indicated that I couldn't see any reason, yes, for deviation.
So I just want to confirm that the principle that you applied here was a correct one, because in paragraph 26 of your judgment, you dismissed the application and you ordered the applicant to pay the cost of the application because the applicant was unsuccessful in his application. So there was a proper application of the principle regarding costs.
Yes.
That's what I wanted to clarify.
Yes, Commissioner, I took the default position.
Yes. Thank you. Thank you, CJ.
Thank you.
Thank you. Commissioner Post.
Thank you, Chief Justice. I too must express my admiration at your strength and fortitude in raising the 4 children, and in standing here today, having faced all the challenges that were thrown at you, the domestic challenges that were thrown at you, I certainly believe that for that you should pat yourself on the back. It is truly, truly remarkable.
Yes, thank you, Commissioner, for that comment.
You have worked in, as you have stated, in the rural areas. And what are the resources like working in the magistrates' court in rural areas? What are the challenges that you face as a magistrate working in the rural areas with resources?
In the past, we had a lot of challenges. I am a coordinator in Zwelitsha Magistrates Court. So from time to time, we hold meetings because of blockages that are caused by lack of resources. For example, you would have a situation where there's no running water, and it affects service delivery because you can't work in a court where there's water and where there's a lot of people packed in one place. I remember at some point I proposed to the DG that we should, the DG then, that we should at least have Jojo tanks, especially for small areas like Simo and Alice. And I think that proposal was taken care of. We have a lot of challenges ranging from faults in regard to electricity. Not only load shedding is no longer, we no longer have it, but there are faults. Sometimes you would find yourself in a situation where you are busy with your court and then, boom, the electricity is gone. But we have a very active regional head in our area. For instance, she procured certain machines called Olympian. So that's our plan B currently. If you experience that problem, then you have plan B in the form of Olympian. So working in the rural courts has caused me to experience those kinds of blockages, but at least that experience has caused me to at least have a way of navigating despite the lack of resources. So in other words, we work under those circumstances.
Thank you. Now, during your acting stint, have you become aware of the anti-sexual harassment policy for judicial officers?
Thank you, Commissioner. It applies to all judicial officers. So I am quite aware of the policy because it was introduced to us by the regional court president. It was also introduced to us by the acting judge president.
And have you acquainted yourself with it?
Yes, I've read the policy, Commissioner.
And have you any ideas about how it can perhaps be improved? Have you considered how it can be improved in its current state?
Yes. I would say it's work in progress. However, when the policy was created, AJP invited us, and I also received that invitation to make an input, which I did to the acting judge president regarding the policy.
Okay.
Yes.
Thank you. That will suffice. Thank you. Thank you, CJ.
Thank you, Commissioner. Any further questions for the candidate commissioners? No. Or Minister?
Just one quick follow-up. During, I think it's interaction with JP Tlalesi, you spoke about almost, I want to be sure, you gave an impression as if the court still functions manually, not on court online. Just to be clear, because my understanding is that we've rolled out court online last year. Do we still function manually? We're not uploading? You gave that impression. Maybe it might not be your problem, but I just wanted to be sure if that's what you meant that is happening.
No, Minister. I was saying there's a lot of participation insofar as injustice is concerned, to the extent that out of 168 matters that I had, the majority of those cases were handled through e-justice system. So I think it's just few that were handled in a conventional way.
So it's not everything, so we're not fully on court online. We're still manual.
We are dual.
Okay. No, thanks.
It does not appear that there are any further questions for you, Ms. Tangani Bakas.
Yes,
Unless
Chief.
there's anything you wish to raise with us, you're excused.
Come again, Chief Justice.
I was saying that unless there is anything you would wish to raise with us, you are free to go.
All right, I just want to thank you, Chief Justice, and the commissioners for giving me an opportunity to participate in this communication or conversation. Thank you very much.
Thank you for coming.
Can I be excused?
Yes, you are.
Yeah. Thank you.
Will you switch on your mic, please? And I was saying, switch on your mic.
Oh, sorry.
Yes, thank you. Good morning, Ms. Colette.
Good morning, CJ.
How are you?
I'm fine, thank you, CJ, and you?
I'm fine, thanks. Are you ready to start?
I am ready.
Good, good. You obtained 2 degrees from Rhodes.
That is correct.
What are they?
It's a BA and an LLB.
All right. And you joined the bar
Yes, I joined the bar straight from university,
in 1986.
1986, yes.
So you've been an advocate all these years.
I've been an advocate all these years.
What kind of practice have you run? What work have you been doing?
I have run a very varied practice. It has a large contingent of pro bono and contingency work. It has encompassed criminal work in my early years, a lot of criminal work, civil law, civil litigation, labor litigation, administrative law, constitutional law. Basically, I've done most things, CJ.
And in between appearing in court and presenting clients, you did other things. You were involved with the Truth and Reconciliation Commission. What exactly did you do there?
Sorry, CJ, I didn't hear the question.
You were involved with the TRC in some respect, and I was asking you to just explain what you did there for us.
Yes, I was involved in the TRC. You will see from my documents that I was involved in the TRC. I was involved in the IEC. I have been involved in land claim matters as well. I've been extensively involved in representing marginalized people, indigent persons. I've done a lot of public litigation as well.
And importantly, you left out your work as a commissioner in the Small Claims Court.
Yes, how can
That's
I
quite
forget?
important.
How can I forget my work as a commissioner of the Small Claims Court? That is quite notable.
I wanted to know what you did in the TRC.
In the TRC, CJ, I was, at the time of the TRC, I had been having a mostly criminal practice at that stage. So obviously, because of that era, I had represented a lot of politically motivated crimes. So I had represented people in those particular matters. So when the TRC arrived, there were very many of my clients who wanted to seek amnesty. So on that basis, although some of them were already convicted, CJ, I prepared amnesty applications for those persons, which I took to the Truth Commission. Besides that, CJ, I also did represent other people at the Truth Commission who were called to the Truth Commission for one or other reason to present evidence or to give an explanation. So it wasn't solely amnesty applications, but the majority of my appearance before the TRC was definitely amnesty applications. And you will see from that, CJ, that I represented a variety of persons before the TRC.
Yeah. You've been involved in community outreach as well. That there's a whole lot of things you do. I don't know where you find the time. And raising 5 children. Now, one of your activities drew my attention. You founded the Unapologetically Female. What is it? The Women Empowerment Initiative.
So, Unapologetically Female, CJ, is an organization that I founded because I believe that women have a certain worth, and sometimes they sell themselves short. So the purpose of Unapologetically Female was to empower not only the females in our profession, but in the broader community. Because if you are sufficiently confident and you have belief in yourself and you have faith in your abilities and you realize that you are the author of your own destiny, if those messages can be carried to the women, then that in itself makes them rise and make a mark for themselves in whatever field they may be. So I'm very passionate about that, CJ, and obviously my history is that I entered into a male-dominated world where I never fitted, let's be honest. Society at the time did not hold a space for women in the profession. And coming from that angle, I've realized that you sometimes need to take a deep breath and realize what your purpose in life actually is. Realize that you can succeed. You've got to want to. And by encouraging women, I have managed to give them those tools to actually succeed. That's the aim of Unapologetically Female in Brief.
I have a big suspicion that you speak for all the women in this room and elsewhere.
Yes, it's not just limited to the legal profession, but of course my passion lies in the legal profession, obviously.
Indeed. I forgot your arbitration certificate. You didn't mention it.
Yes, I do have an arbitration certificate.
Yeah. You started acting as a judge in the Eastern Cape Division when, in 2022?
In 2022, July.
Until 2025?
Well, I'm presently acting.
Oh, you are still acting?
Yes, I'm presently acting.
So how long has your acting stint, what does it amount to in all?
In total, besides the ones now, it's been about 45 weeks. That's excluding the part herds that continued in between that. And presently, I've been acting since the 30th of March.
Mm-hmm. In which seats of that division have you sat?
I'm presently in Bishu. Did you ask which ones I've acted in?
Where else have you sat?
I've sat through all the divisions.
All right. And what kind of cases have you adjudicated?
I've been exposed to everything, CJ. I've been exposed to civil trials, criminal appeals, full bench appeals, civil appeals, taxation reviews, motion court, urgent motion court, recess duty. I've done it all.
You've done it all. And wrote judgments?
Yes, I've written 85 judgments to date.
Any of them reported?
I think there's about 5 that I've come across that are reported.
Any taken on appeal, upheld, overturned?
One of my cost orders was taken on appeal, and it was... Sorry, CJ?
You say you were taken on appeal on costs?
On costs, yes. My cost order was taken on appeal, and the full bench took a different view to me and overturned my costs order and reverted to the general rule.
That's unusual. You must have been very wrong.
Well, CJ, we have the appellate. It happens. We have the appellate functionary for that purpose.
Indeed. I'm going to give our objections committee an opportunity to report on, I think it's 2 complaints that were lodged against you by a certain individual. Is it Commissioner Matolo Lepu?
Okay, thank you. Good morning, Advocate College.
Good morning, Commissioner.
Yeah, I think you have seen that there were 2 objections against your candidacy by Dr. Ako. And the first objection against you is that you were a prosecutor with the Department of Education and an arbitrator. He alleges that you delayed the hearings because, according to him, you belonged to an internal cabal, inner cabal sort of, and that was from 2017, but he doesn't state up to when, and that you delayed these hearings because you wanted to make more money, and most of your decisions were predetermined. And what I just want you to clarify to this body, because we viewed this as quite a serious, but we just wanted to hear your view about this objection against your candidacy. The second one is that you were sued by FNB and judgment was taken against you. You went on appeal to the SCA, you represented yourself, and you were under debt review. And according to him, he's the same complainant, objector actually. He says he's very worried about your financial status or whether you'll be able to manage your financial affairs, once you are appointed. So I just wanted you to comment on the two objections and just satisfy this body why we should appoint you. Thank you.
Thank you, Commissioner. I think, Commissioner, you have tried to summarize a very long objection that was filed. May I start off by saying that, as counsel, any instruction that I receive relative to any department would be via the state attorney. So that instruction would be traceable and it would be open for anybody to see the length of time that a particular matter took. I have no interest whatsoever in delaying matters. Quite on the contrary, as far as I'm concerned, justice is served if matters are concluded promptly. The particular matter that you are referring to, I was the initiator in that matter. I was instructed by the state attorney to initiate disciplinary proceedings against a certain person, which I did. It culminated in a disciplinary hearing and thereafter in an arbitration, after which the individual concerned was acquitted. I did not delay the proceedings. Those particular proceedings happened, the arbitration happened over the period of COVID for that matter, and also the bargaining council determines when and how we sit. And the bargaining council would ordinarily set the matter down for 2 days. I have not been involved in any impropriety. I did not sit as a chairperson and initiator in the education department of my own asking, because I felt that if I initiated, as I did, frequently for the education department, there may have been a perception of bias if I had presided. So I requested not to preside in the education department. I have presided in other departments. I have not been involved in any collusive activities. I have not been involved in any matters which were for my own personal gain. All fees that were rendered would have been rendered and approved via the state attorney in consultation with their client. So I think that possibly would answer your first objection, Commissioner, unless there's anything further on that objection before I move to the next one.
Okay, just one question. Do you know the complainant, the objector?
Do I know her?
Yeah.
Not personally, Commissioner, but she was one of the many people over my years that I have initiated disciplinary proceedings against. So not personally. And frankly, I was rather concerned with the fact that she should raise the concerns that she did, because I always believe in treating people with dignity and with respect, and I did nothing different as far as she was concerned. As a matter of fact, the very senior counsel that represented her in the arbitration proceedings is one of my references and nominators in this particular application before the Commission. So I'm quite sure that he would not have felt comfortable in recommending me if he had found that I'd acted in some untoward manner during that particular matter. Further to that, Commissioner, I would draw attention to the fact that I have a reference from the Chief State Law Advisor who has actually mentioned that the department receives value for money when they instruct me. So I would say that there's no objective evidence before this commission that any of the objections that were raised in by that particular member of the public are in fact correct.
Okay, thank you. Just the second one, the issue of whether you are able to conduct your financial affairs, because it's the same object actually.
Sorry, Commissioner, I didn't quite understand what you said.
That's why I asked whether you knew the objector, because these are the two complaints that comes from him, from her. Yeah.
No, I don't. I don't know her personally.
Okay. Just address
Commissioner.
the second one.
That's the First National Bank one.
Yes.
Regarding the First National Bank issue, Commissioner, maybe it's best for me to start at the beginning. CJ has already mentioned the fact that I have 5 children. That is in fact correct. As you will know, if you have had regard to my application, you will see that I have done a lot of contingency work and pro bono work. And as a woman in the profession, the large paying briefs didn't often come my way, but I nonetheless managed to make a livable earning. Unfortunately, personal circumstances arose under which I all of a sudden had to take full responsibility as the breadwinner of my family. And with that came a situation of having to make means stretch. And with that came having to pay for things that were taken or agreements that had been entered into in times when finances were better because there were 2 incomes coming into the family. At that particular time, and I think it's important to know this, I was in fact appearing for debt review clients in court on a contingency and a pro bono basis and protecting their rights. And when this arose in my life, one of the attorneys with whom I was working suggested that whilst I sold my immovable property to alleviate my debt burden, I should momentarily go under debt review to give me that breather. And that is what I did. I had started to liquidate the immovable property that I had. What I didn't anticipate was that First National Bank would decide to issue summons against me for one of the properties that I had, and in so doing, that matter landed before the court and resulted in a summary judgment. I never appeared for myself in that matter. At that time, there was a lot of uncertainty around Section 8610 of the Credit Act. And I can perhaps best describe it as Chrysal J did. And that was, it was as if the debtor was being afforded an umbrella, but the minute it started to rain, the umbrella was being snatched away. So there was a lot of uncertainty around 8610 at that stage. From my own point of view, my clients and clients that I had been serving fell into the same category regarding the interpretation of 8610. The Western Cape found it so significant that in the Papier matter, the Western Cape convened a full bench to decide on this matter. And interestingly, they decided that debt review could not be cancelled even if the 60 days had expired because the matter had been referred to court. Obviously, that wasn't binding on the rest of the country. So effectively what was happening is debtors were going under debt review. There was a huge backlog of these matters in the magistrate's court, couldn't cope. And on the 61st day, the credit providers were cancelling the debt review. There were conflicting decisions on this. Even though my matter was to be, my personal matter was to be settled with the proceeds of the immovable property. I elected to take it to the Supreme Court of Appeal to decide upon the conflict, to have some certainty going forward. And the intention was not at the outset that I would argue that matter. But what happened was that because these matters were being delayed in the court as a result of my matter pending before the Supreme Court of Appeal, the bank took it upon themselves to bring an urgent application to the Supreme Court of Appeal to expedite the hearing date of the appeal, for obvious reasons. And that being the case, my time was incredibly limited to find somebody who was prepared to take this case on a pro bono basis. And in fact, it was nigh impossible. So I was faced with two options. Either I withdrew my appeal, which I could have done in any event because the settlement of my debt was imminent. Or alternatively, I proceeded with it and represented myself. And I took the latter option. Despite my personal discomfort, I did it for the greater good. I did it because procedurally, the courts needed to end this conflict. And I went to the Supreme Court of Appeal and I argued the matter, and it didn't go in my favor. So it was never about debt avoidance, never went in my favor. But what it did do, and there was no cost order that was granted against me, but what it did do is it created awareness for that section. It was on everybody's lips. After that Supreme Court of Appeal judgment, I was asked to take it to the Constitutional Court, whether I would. And I agreed to. Fortunately, a senior counsel stepped forward to prepare those papers to appeal to the Supreme Court of Appeal. Sorry, to the Constitutional Court, my apologies. But the Constitutional Court turned it down, saying that it wasn't in public interest. Thereafter, the Constitutional Court interpreted 8611 a little bit more widely than it had been interpreted up until then, but debtors were still faced with the inevitable debt review being cancelled after 60 days. Then, in 2014, the Act was amended. The legislature came to the rescue. The legislature looked at the purposes of interpretation of the debt review legislation. And that section, that 8610 section, that had been the subject of my appeal years before, some 5 years before, I think it was changed to the extent that we had been arguing for all along, and that was that that persons that were under debt review would not have their debt review cancelled if the matter was pending before court. So in answer to your question, at the time, I was conflicted with financial constraints. I immediately sought a way to address them, and I in fact did. I satisfied all indebtedness. I, in fact, still own the very property that was the subject matter of the court case. And besides that, I've had no problems since. The Commission does not need to concern itself about my financial well-being. I am financially stable, and I have been for a number of years. Do you need any more information from me, Commissioner?
No, thank you. Thank you. We just wanted you to clarify the objections, but I'm quite happy. I think the Commission is happy.
Thank you, Commissioner.
Thank you, Commissioner.
And thanks for that declaration, Advocate Colette. I'm sure you'll understand that the concern is that we do not want judges who cannot manage their own financial affairs for obvious reasons.
Of obvious reasons, of course,
Yeah.
CJ, but the affirmation is there. My financial affairs are in order.
And nothing like this will happen
No.
again.
I
Well,
wouldn't
at least
like-
while you're a judge, if you are appointed.
I wouldn't like to walk this route again. It was purely circumstances dictated by the time.
While I'm still on my feet, just out of curiosity, you have not taken silk in almost 40 years in practice. May I ask why?
Yes, Commissioner, I thought you might ask why. Commissioner, over the years, my career never took the traditional silk trajectory. I had a very broad practice, encompassing a large contingent of pro bono and contingency, public interest and service matters, alongside my criminal, civil and labor practice. I didn't set out at building a silk portfolio. I was more guided by the service and the clients that came across my path. I regarded the quality of the work that I produced as paramount. And for me, because of the varied amount of work that I did and my willingness to accept any brief, no matter how small, no matter whether it was lucrative or not, meant that I wasn't walking perhaps what was traditionally regarded as the silk path. But for me, in all honesty, the accolade of a satisfied client was the recognition that I was looking for throughout my career. The mere fact that I was briefed by somebody who had entrusted me with their case felt sufficient, and I felt sufficiently rewarded in that respect. But I understand that taking silk is a mark of seniority in the profession, and I understand that it comes with the perceived view of excellency. And that's the truth. So I'm happy to report, CJ, that recently, after having several acting stints and accumulating a number of judgments alongside my professional career, I decided to apply for silk. I have indeed applied for silk to my bar. My silk committee at my bar has approved my silk status, and it has been forwarded to the JP. Does that answer your question, CJ?
Good to hear.
Thank you, CJ.
CJ, can I just follow up on the silk issue? Can I just follow up on the silk issue? Advocate College, I'm just happy you raised this issue about the criteria about silk. Have you seen the new criteria that has been issued by the Department of Justice regarding the appointment of silk?
Yes.
And did you comment? Because some of the criteria is to include people like yourself who have been very active in the public interest law. Did you comment? Thanks.
Yes, yes. Commissioner, if I may comment, I sit on the LPC, so I am fully aware of the criteria as contained and as that has now been formulated. And I welcome that criteria. I absolutely welcome it. What I like about that criteria is that it encompasses more than just work. It encompasses your community involvement. It encompasses who you are and what you've contributed to transformation. And I can't with all certainty say that that is the way that silk was approached in the past. But may I add that when I prepared my silk application, because the LPC's, I think they called it the Senior Counsel Award, is still pending and was still pending, I prepared my silk application based on those criteria, which I actually 100% agree with, because I think that if you're going to put yourself forward as somebody that's senior in the profession, you need to put your money where your mouth is. And it's not just about how much work you've done, how much money you've made, how big your cases were. It's not the size of the case that counts. What counts is the service that you've rendered to society. What counts is what do you do beyond your legal profession? And that is why I was comfortable to hand in a silk application, because beyond my legal career, I contribute to the community willingly and openly, and I have always done that. My career has not been money-driven. My career has always been in service of the voiceless, the marginalized, the people who didn't, the indigent, the people who didn't have money to come to court. I've never judged anybody in representing them. What they had done or what they were accused of or what their philosophy was not my concern. It was always about fairness. So from my point of view, I laud the new criteria, Commissioner. Absolutely.
Thank you.
Thank you, Commissioner. Back to the traditional list. AJP?
Thank you, Chief Justice. Good morning, Ms.
Good morning, AJP.
I see from your application form that a lot of your acting stints started to run from the 17th of January 2023.
Sorry, AJP, I'm battling to hear you.
A lot of your acting stints started to run from the 17th of January 2023. Am I right?
Could be, yes.
So do you know how many weeks that has given you from that date?
Not particularly.
You've told us it's 45 weeks.
Yes, I think it's 43 to 45 weeks if I counted correctly, AJP. If I can recall, 2022, I acted for 2 weeks, and then I acted for another week in the December. So I think I acted 2 weeks in the July, and I acted 1 week in the December of 2022, if I'm correct, AJP.
You are correct, I see that.
Am I? Well, my memory doesn't fail me. And then from 2023, yes, I think the majority of my stint started from 2023, AJP.
And you have been conducting training sessions in the area of Kwakombo. Can you say something about that?
About the training sessions?
Training sessions that you conduct involving legal practitioners.
Yes. So I have always mentored people individually in various areas of law. And one of the areas which I believe is absolutely crucial to the efficiency of the profession is a knowledge of the rules relating to court. And when I sat on the bench, I began to realize that there were a lot of instances where the rules were incorrectly applied or not properly understood. So I decided to take what was ordinarily individual mentorship into mentorship for all practitioners. So it's not just for advocates, pupils, candidate attorneys, or seasoned attorneys. It's also for students. And in fact, I even have members of the registrar staff that come to listen to these lectures. When I say lecture, I want to clarify that this is not the sort of lecture that we have in a university environment. It is more a mentorship session where I impart the rules, explain them practically, how they apply, and I invite constant interaction from those that are present so that they can engage with me and we can solve the problem then and there. Because it makes little sense to stand in front of a room and preach about the rules if the people don't understand what you're talking about. Because understanding is empowerment. I was absolutely flabbergasted by the response that I've had. As you will know, AJP, these are ongoing. I'm still doing them. I've been doing them for quite a period of time, and I've interspersed in those, let's call them lectures, areas where I can give practitioners working knowledge. For example, the recognition of customary unions. I wanted to give a working knowledge on that. On evictions, a working knowledge on that. So I've taken it one step higher than that, but I've done this because it's all good and well for us to, especially as judicial officers, to say nobody knows the rules. But sometimes just to take a little bit of time to try and bridge that gap is more meaningful than just putting a plaster on it and saying, well, they don't know what they're doing. So that was the rationale behind it, AJP. Yes.
You have worked as an AJ at all the stations of the Eastern Cape Division, correct?
That is correct, AJP.
That is including Mthatha.
That is including Mthatha.
And what has been your experience as an AJ working at those areas?
At all of them?
Working at those areas, what has been your experience that you can tell us about?
I have had a pleasant experience at all the divisions. It would be wrong of me to sit here and say that there aren't sometimes teething problems, but there are. But I believe that the responsibility of the judge who may be presiding over a matter that has teething problems is to resolve those as best as they can. From my point of view, I'm encouraged by case flow management. I think not only was it a useful innovation in the Uniform Rules of Court under Rule 37A, but I appreciate the case flow management that is happening in our division, AJP, because I think that it has strengthened the preparedness of cases to a large extent. From my point of view, I think it's that the more we implement rules properly, it will dispense with uncertainty and it will encourage efficiency in the courts. Whilst I say we need to focus on the rules, that goes with a measure of flexibility in certain circumstances and fairness. But fairness can never be replaced by, or can never excuse, inefficiency. Generally, I believe that the courts run efficiently in the circumstances, and it's very much up to the individual judges as well to make sure that their courts are as efficient as possible.
As an acting judge, you are judge yourself. What comment can you make on your interaction with other judges? I'm referring to collegiality, that is compassion and cooperation towards your fellow colleagues.
Me personally?
You personally, what has been?
I believe I have a good rapport with all the sitting judges and the acting judges that come in at the same time as I do. There is good camaraderie amongst the judges in our division. The tea room gatherings are very pleasant. There's laughs, there's assistance. The judges in the division are very collegial. I have never been turned away by a single judge that I have gone to ask for assistance, because obviously as an acting judge you don't know everything and you need to learn, and you would learn from those that are already in the division. So I can't say that I have had any barriers or I've had any misgivings or any maltreatment or not being able to get on with anybody in the division.
I cannot avoid it, but also ask you a question relating to the sexual harassment policy that the courts have adopted. If you are aware of it, and if you do, what comment can you give to that?
Is your question whether I'm aware of the sexual harassment policy?
Yes, and what comment you can make about its relevance, so to speak.
The sexual harassment policy is a policy that's been adopted, and gratefully so. It feeds into the constitutional imperatives of dignity, equality, and security of person, as well as having a safe working environment. Any policy that ensures that is a welcome policy. I believe that the sexual harassment policy strengthens those concepts, those rights. Obviously, from the point of view of a complainant, one would have to accept the information that the complainant would provide, offer the necessary support. The matter should be properly investigated, and it should follow a fair procedure as dictated in that policy to arrive at an outcome which is in the interests of justice and would necessarily reaffirm the importance of a safe work environment and the respect for the constitutional rights of those that operate in that environment.
Thank you, Ms. Colette.
Thank you,
Chief
AJP.
Justice.
Premier?
Thank you very much, Chief Justice. Good morning, Advocate Colette.
Good morning, Commissioner.
Thank you so much. In your pleasant experience as an acting judge, as you have indicated across, I would wish you probably to indicate to me from where you are, what are the challenges the Eastern Cape courts do face in your own experience? One. Second question from me would be that which of those challenges would you assist in resolving, and what value would you add to the High Court division? Lastly, do you believe in transformation? I think probably one of my colleagues here might ask the question. Your attitude on rationalization that was proposed by Justice Dikgang Moseneke, that includes the relocation of the city from Grahamstown to Bishop.
So if I understand what you're asking me, Commissioner, you're asking me to comment on what the challenges there are in the courts in the Eastern Cape. That's the first thing. And the second thing, you were wanting me to comment on the rationalization of the courts in the Eastern Cape. Do I understand you correctly, Commissioner?
You said yes, but including what role would you play, what contribution, the value that you think you will add?
What contribution can I make?
Yes, in dealing with challenges that...
In resolving those challenges, yeah. Yes. So, the courts in the Eastern Cape are situated in 4 different places, and then we have the Circuit Division in Kugompo. I believe that accessibility to court is paramount. It's entrenched in the Constitution in Section 34 in any event. Accessibility, it gives credence and credibility to the justice system. We would know that. So I would say that the challenges possibly are that our courts are not that large structurally. So, for example, if you look at Bishu, it services a large area, but it only has 1 civil court and 2 criminal courts. It does have the extension in Kugompo of 2 additional civil courts, but we do have, it does cover a large jurisdictional area. I don't think that people actually realize how big the jurisdictional area of the Eastern Cape actually is. It's a massive area. And from my point of view, one of the challenges would be a lack of structural courts available to dispense the justice and to hear the cases. That would be one of my comments. As far as the rationalization of the courts is concerned, again, when one looks at rationalization, we go back to Section 34 of the Constitution, obviously accessibility. We need to look at efficient use of state resources. We need to look at how best the administration of justice would be fulfilled at these courts. And also, one would need to factor in how close the seat of the court, for example, is to the provincial legislature. So, I've been party of this debate over many years. I've listened to all persons' concerns. And I understand the historical feelings relating to the present seat of the court. And I understand the wish to move it to Bishu, probably because of its proximity and probably because it is likely to be more accessible to very many of the rural areas. But at the end of the day, this is a constitutional imperative. There needs to be a decision made taking all of the factors into consideration, Commissioner. All the factors. The efficiency, the accessibility, administration, the actual physical capability of the court building. So it's not one that, gratefully, I have to make the decision on. But I would say, after considering all those factors, I'm very confident that the correct decision would be made regarding the rationalization of the court in the Eastern Cape. Your next question was, what would I do personally in this regard? Well, one cannot move away from the fact that we have a large indigent population that surrounds our courts. Can't close your eyes to that. People that come to court, especially in this day and age, have limited resources to litigate with. So I would say that firstly, the important factor would be to ensure that procedure is followed, that the rules remain paramount, so that we can dispense with the cases as expeditiously as possible and prevent backlogs. The next point would be that judgments should be delivered as expeditiously as possible and as clearly as possible, so that parties understand what the outcome is, so that there's no lingering. Third point for me would be the way in which we conduct the proceedings. And there, if you would indulge me, the principles of Ubuntu would be very paramount in how I would approach courts going forward. And of course, that embodies respect, it embodies dignity, it embodies humanity. So if litigants are comfortable that the courts are going to afford them those rights, that would also make the courts feel more accessible to them, because after all, we're a shared community. We're not just a court in isolation. We serve the community, and it would also reaffirm the faith of the community in the courts. So I think I have answered your question on giving the 4 areas that I personally would approach, Commissioner, in making courts more accessible. Oh, and one last one, Commissioner. I think I would also interface with the pro bono initiatives of the bar and of the LPC and of the other legal associations that provide resources or monetary initiatives for litigation. Have I answered your question, Commissioner? Thank you.
Thank you. Any Minister?
Thank you very much, CJ. Good morning, Advocate Colette.
Good morning.
The first question I have, it's around the issue of death penalty.
Yes.
You have had clients that face death penalty or death sentences imposed, and when the abolishment was announced by the Concord, you celebrated this milestone, I think, like many of us in the country. But today we are finding ourselves as a country where many women organizations and individual citizens, because of the high level of crimes, but the nature of the violent crimes that we're experiencing, are calling for death sentences. Having been seeing that the past and celebrated, what do you think should be done in order to avert going back to that? Or even does your opinion still stand in terms of celebrating the abolishment of death sentence?
Commissioner, we could never go back to the death penalty because we have a constitutional supremacy. And that constitution guarantees the right of life and dignity to persons. I, as you know, have represented numerous persons who have been accused of serious crimes over the years. The death penalty was a sentence that existed under the system of parliamentary sovereignty. From a personal point of view, I didn't agree with it. But at the time, it was the law of the land. So my personal views are not of consequence, as are they not of consequence now. I recognize the increasing crime in our country. I recognize that. I recognize that people want to hold others accountable and they want them to be appropriately sentenced. What we have in our country, and many people don't really rely on it, is we have prescribed minimum sentences. So our legislature has interfaced with this problem, and they have prescribed those sentences for certain crimes. I believe that those are adequate, and they are consistent with the Constitution. I cannot sit here and advocate for the death penalty. Not something that is inconsistent with a Constitution that I have walked alongside since before the days of its existence. I was one of those persons that was in those courts when the death sentence was handed down. It is something you never forget. It is the most harrowing experience ever. And when the death sentence was abolished, I was not the only one that felt that comfort. And I was comforted that it could never happen again because our Constitution assures everybody of the right to life, the right of dignity, and to unfair treatment, unfair and inhumane treatment. Have I answered your question, Commissioner?
Definitely you have.
Thank you.
The second one, which I think when you spoke, when the CJ took you through your CV, was around when you spoke about the Unapologetically Women Organization.
Yes.
I noted particularly on your question 5 of the questionnaire, which asked if there is any matter you wish to bring to the attention of the Commission. You mentioned that you are 62 years old, and you sharply raised the fact that male colleagues of the same age have been appointed and served well in the bench. My suspicion is that you raised this in the fact to highlight the biasness against the appointment of female leaders or female judges of your age. Could you perhaps share with us the issue of gender biasness in terms of appointment? Do you think that that remains a challenge for women in terms of the transformation of our system?
Commissioner, I have lived through 2 dispensations. The first dispensation did not make space for women in the workplace. That was the society that we lived in at the time. Since the advent of the Constitution has sought to bring about transformation in that respect and has created space for women in the profession and in other professions. Has transformation happened optimally? Well, as with all things, things take time. I mentioned that particularly, Commissioner, because we do indeed, in our own division, have 2 candidates who are appointed at an older age, or a more mature age. I hate to use the word older because then I seem like an old person, right? At a more mature age, I will use the correct word, at a more mature age. And they serve their duty, perform their duties with distinction. I come before you as a more mature person with 40 years of experience over a vast number of disciplines. And I mentioned that because with the transformation process, should I not be afforded the opportunity, despite my age, to serve the judiciary? I believe that I should. And that was why I mentioned it with respect, Commissioner, not to in any manner or by any means say that those colleagues or those persons on the bench were elevated above me. I wasn't part of the interviews that they participated in, but just to bring attention to the fact that I can. My time is now. I'm mature.
I don't think you should be apologetic. We still live in a patriarchal society. We're still transforming.
We do. As I said to you, Commissioner, transformation with everything takes time. As women, we also need to stand up and make sure that it happens. Hence, I say, I'm here. I'm not 62 anymore, by the way, Commissioner. I'm now 63. I've had my birthday. But nonetheless, I am here. I am ready. I'm intellectually stable. I have no encumbrances. I'm prepared to start. I have experience. So, in line with transformation, I believe I should be given a chance.
Thank you, CJ. Thanks.
Well, if you were appointed, you'd still have a whole 12 years to serve. That's a long, long time.
12 years is a very long time. I can't even imagine where 40 years went, CJ.
I know how that feels.
Time is very
much
relative.
older than me.
Yes.
Okay. Chairperson, followed by JP Jaleti.
No, thank you very much, CJ. Good morning, Advocate Colette.
Good morning, Commissioner.
I must say your contribution to transformation and your selflessness is truly remarkable.
Thank
and
you,
I want to
Commissioner.
commend you for that.
Thank you very much, Commissioner.
You also played a significant role in community programs. Now, my question is, how do you incorporate the feedback you receive from communities in order to improve the court services?
I believe that the important issue is not only to hear what people are saying on the ground, but to actually listen. Everybody can hear, but very people actually listen. From my point of view, I have always regarded what people say as paramountly important, both in my profession and any other profession that I may occupy in the future. It's important to hear that and to have a keen understanding as to what the complaints and what the misapprehensions and what the perceptions are of the profession and of the bench and of the courts. And once hearing and listening to those, to bring those to the attention of people that can do something about it. In other words, those that are in authority. So my Community Initiatives Commissioner, do assist me in that regard, because although I don't necessarily go out there and advertise what my profession is, because it's not relevant in most of my community outreaches, I do, once the people inevitably find out, I do hear what their misgivings are, what their concerns are, and what issues they raise. And I am that type of person. I'm not going to sit back and not do something about it. I will raise awareness. People will not like me for raising awareness, but I will raise awareness where I need to, so as to remedy or try and make matters better for those that have raised issues. Commissioner.
Thank you very much. My last question, I just want to get a sense from you, particularly your views with regards to the public perception and trust in the judiciary amidst the ongoing societal challenges, and how do you think we should address the challenges?
Commissioner, earlier I touched on the issue of Ubuntu. I revert to that and maybe just take it a little further than I did in those circumstances. The concept, whilst not replacing the judiciary's right or the judiciary's requirement, the court's requirement of dispensing justice in terms of the Constitution and law and precedent, should certainly define how those services are delivered. It is incredibly important that the courts are regarded as effective, that the courts are regarded as places where justice will not only be seen to be done, but actually be done. It's important that there is confidence in the courts by the communities, because without community confidence, I don't believe that the courts are succeeding in their function. It's broader than just applying the law. Obviously, you've got to apply the law. You've got to apply the Constitution. But the Constitution tells us dignity, respect. The Constitution tells us make it accessible. I have been faced by people who come to court that are unrepresented. Those sort of people need to be dealt with dignity. They're not there because they choose to be there very often. They're there because they don't have the resources to employ somebody to be there on their behalf. Not everybody is prepared to take pro bono and contingency work. Not everybody is prepared to stand for others when there's not a financial reward. As a judicial officer, when I've been faced with those circumstances, I have always made sure that the litigant is treated with respect, that the litigant understands the procedure that is unfolding in the court, and that the litigant has been advised of their rights and how they should go about defending themselves, or alternatively solving or seeking a solution for their predicament. Very often, and particularly in our division, counsel will stand up and offer to assist that person. And a short adjournment for an unrepresented person to go and discuss with maybe the applicant's counsel and the person who may have stood up to assist, sometimes assists in building some form of credibility and some form of way forward for that litigant. I have also had litigants before me in eviction applications that have been unrepresented. I have to apply the law, but I need to apply the law in such a way that that person feels heard, listened to, is treated with dignity, and understands the law which I am going to apply. So I don't know whether I've answered your question, Commissioner, but that is the way I view it.
Certainly, thank you very much. And from the bottom of my heart, I wish you all the best in life. Thank you.
Thank you so much, Commissioner.
Thank you. Good day, Ms. Colette Tlalezi here. Can see me now.
Good morning, Commissioner.
Yeah. Just in a point form, you have indicated as part of your litigation work, 30% was devoted to several fields of law, and amongst them is customary law.
Yes.
Just in a point form, what kind of dispute or issues did you litigate on, without describing and getting into the details there?
In the customary law section,
Yes.
Commissioner, I'm privileged to have performed most of my professional duties in the Eastern Cape.
Yes, yes.
And I started off at the Bishu Bar. So a lot of my work was in Bishu, which serves a huge rural area. Now, the Black Administration Act, of which I'm sure most of us are aware, had certain, I'd like to say, non-recognition of customary unions. And let me, without wanting to criticize legislation and tread on a very dangerous field, let me say that it didn't serve the purposes of the major populace regarding customary unions, the registration thereof, etc. Most of my customary law work revolved around customary unions, the registration thereof, the recognition thereof, and it also revolved around intestate succession matters such as that. And then, of course, in later years, with the Recognition of Customary Unions Act coming into play, the landscape shifted somewhat, and I became involved in matters involving the new Act and the recognition of customary unions. It's an area of law which I'm rather passionate about because I've seen the transition. So on one hand, people could say, well, that's because you're old. Well, it's not so much it's that I've lived through these different acts. And I've loved the progression, and I've enjoyed giving effect to the new act, which I believed has remedied what the old act had. So that, to answer your question, is what my customary law practice involved. Customary unions and maybe intestate law, yes.
Any traditional leadership disputes you were not involved in those?
Sorry, I never heard
Any
the question.
traditional leadership disputes?
Not particularly that I can recall, Commissioner. Mostly to do with intestate succession and having to look at certain customs as far as that's concerned. And then I don't particularly regard it as customary as such, but matters relating to burials are very common in that particular jurisdictional area, Commissioner. I believe that it's imperative that practitioners have a working knowledge of the law relating specifically to customary unions and that new act, because it interfaces with intestate succession
Yes.
and succession in general, yes.
Yes. Other than adjudicative work, is there any particular strength that you can assist the leadership of the court with? Have you thought of that? If not, it's not a problem.
Commissioner, I'm battling to hear you, sorry.
Yeah, I say, other than adjudication of cases, is there any strength that will bring to the court in which you can assist the leadership of the court to deal or address? If you have thought, yeah, sorry.
So
As a
you-
judge, you'll be adjudicating cases, but
Yes.
in addition to that, there might be something that you can introduce or strengthen the leadership of the court or advise the court with, the leadership with. Have you thought of anything? Given your vast experience as counsel and involvement in public litigation and other disputes that you have involved in. It's something, if you have thought about it, I
Yes.
haven't have a problem.
I'm thinking as you're asking, Commissioner, as to what that would be. The Commissioner, I think that what must be self-evident from my career, my portfolio, is that I'm very passionate about access to court for all persons. That to me is something that if there was some way, and I don't know sitting here right now what that would be, if there was some way that I could make the court more accessible to persons who do not have the financial resources to litigate, I think that would be where I would try and make a difference.
I see.
Commissioner.
Thank you, Ms. Collins. Thank you, Stephen.
DP Zondi?
Hey, good day, Ms. Collins.
Good morning, Commissioner.
I don't have a question per se, but just to comment, it's just a comment. Your fight that you put up to fight the sections 8610 was not in vain because as you have correctly pointed out, the legislation was subsequently amended, and during the Collett versus FNP case, there were a lot of controversy, even in Western Cape where I was a judge. We had cases like West Bank and Papia, and which was the full bench, because we had a problem with Section 8610.
Commissioner.
So I just want to commend you for the fight that you put up, and that fight was not in vain.
Commissioner, I must apologize, but the acoustics are not that great.
Oh.
And I didn't actually hear the import of your
Sorry.
question.
Sorry, no. I don't have a question per se,
Yes.
but it's a comment.
Yes.
On what you did regarding Section 8610
Yes.
of the Credit Act.
Yes.
As you correctly pointed out, the section was subsequently amended after the Collett versus FNP case, and it reflected what you wanted to achieve. And so your fight was not in vain. So I must commend you for the fight that you put up.
Thank you, Commissioner. I was very comforted when that amendment came about. It was very disappointing after the appeal case, I must admit. A lot of us felt disillusioned, but you have to respect the authority of the SCA, and I did indeed as a professional, and explained that they had given a judgment. But I was, to a large extent, comforted when the legislature stepped in and amended what I believed was a section that was not exactly in line with the aims and the objectives of the statute. I appreciate your comment, Commissioner.
Commissioner Moimang?
Thank you, Chief Justice. Good morning, the Advocate College.
Good morning, Commissioner.
Thank you. Just on one question from my side, informed by what you said in your questionnaire, it's page 26, where you say that your career has been one of using the law in service of justice quietly. You now seek to bring this experience to constitutionalism, transformation, and access to justice to the bench. That's what you say. So now the question that I want to pose is as to whether this rich experience of activism and commitment to constitutionalism, are you going to turn the bench into an activist forum? And whether it's the second one is the tension between judicial activism and the independence of the judiciary in an instance where the court is called upon to assert the right to dignity, the right to property, and the right to housing. Thank you.
So, Commissioner, I'm trying. I lost you a little way along. I just, if you could just repeat the question for me.
The question was, given your commitment to constitutionalism,
yes,
are you going to turn our benches into an activist forum? And whether is there a tension between judicial activism in its quest to promote the right to equality, justice and dignity, and the independence of the judiciary, particularly around the need to respect the separation of powers. Thank you.
Thank you, Commissioner. I'm touched by the fact that you would think that I'm an activist. I am not so much an activist as such as an upholder of the Constitution and what it embodies. I can't, maybe my perception of the Constitution is more jealous than others because of my historical and institutional knowledge. So when it comes to dignity, when it comes to humanity, when it comes to equality, when it comes to dispensing justice with fairness and without prejudice, I believe that those are what everybody should be doing, not just me. And if they're not doing them, then they need to get on board and start doing them, as far as I'm concerned. I must say, and I think I'd like to say this up front. The very first time that I acted in the criminal court in Bishu, where I had cut my teeth. And when I walked into that criminal court on that day, it felt like coming home. Prior to that, I swore an oath of office. And I remember listening to the words that I swore. It was to be faithful to the Republic of South Africa. It was to uphold the Constitution. It was to treat people with dignity and uphold the rights entrenched in that Constitution. It was to apply the law according to the Constitution and according to the law, the legal prescripts of the country. And importantly, I was to do it without fear, favor, or prejudice. And as I swore that oath of office for the first time, I realized that that was what my entire career had been about. So the transition to the bench and the swearing of that oath was what I had always been familiar doing in the first place. So to answer your question, Commissioner, I'm going to continue to be what I've always been, an upholder of the Constitution, an upholder of the rights of people, an upholder of dignity, dispensing justice without fear or favor or prejudice, and making sure that the reputation that the courts have, definitely through me presiding, would be a favorable one to the communities. I hope I've answered your question, Commissioner.
Thank you, Advocate Collett. Thank you, CJ.
Commissioner Mangena, followed by Prof.
Thank you, CJ. Good afternoon, Advocate Collett.
Good afternoon, Commissioner.
Yes, I must say at the outset that with people like you, there is hope for our country. It is not often that one comes across people so determined and committed to the ideals of and the values of the Constitution.
Thank you for that kind comment, Commissioner.
Whatever depression that one might have had, at least there is hope out of the good work that you have done. I've got two questions for you. In the matter of money versus the state, it was an appeal brought by that student who was sent to direct imprisonment, 5 years direct imprisonment, because NSFAS had erroneously paid 40 million into her account.
Yes.
I was impressed with the manner in which you reasoned around correctional supervision. In fact, the entirety of Section 276I and H. Do you think, or in your opinion, do you think that our magistrates and courts in general are effectively using that section to address overcrowding in our prisons, but generally applying the triad of sentencing as we know it?
Thank you for your positive comments, Commissioner. Again, Section 276 was a sentencing option that came into play after I'd started practicing in criminal law. So we were all very encouraged by that particular section, and doing a lot of criminal law at the time, perhaps it was greater on my radar than most people. When sentencing a person, and obviously looking at the circumstances surrounding the crime, I sometimes do find, and I must honestly say, that the sentence of correctional supervision is brushed under the carpet because it's regarded as not a form of sanction. It's regarded as a soft touch, or it's regarded as not suitable. We have overcrowding in our prisons, we know this. There are some cases where imprisonment is the only suitable option. But in that particular case of that young woman, as you correctly pointed out, I looked at many issues, and I considered that 276 was appropriate because it goes to restoration as well, restorative justice, does it not, at the end of the day? And that's important for me. She was making reparation. She could be rehabilitated. The crime didn't demand her to be incarcerated. She had a minor child. What happened was, well, I still don't know how it happened, but does it matter? She got all that money in her bank account, and yes, so she spent some of it. But did that mean that we should just take a blinkered approach and say, imprisonment, 5 years? I didn't agree with that. So in answer to your question, maybe the reason why 276 is not applied often or often enough is the lack of understanding relating to the import of that section, what it actually means to be given correctional supervision or correctional supervision sentence under 276. And as you will remember in that judgment, Commissioner, it was coupled with a suspended sentence. So that satisfied the deterrent effect as well. So maybe a course or maybe some training on that particular section might well make a difference. As I've said, sometimes rules are not applied or concepts are not applied not because people aren't aware of them, but because people don't understand them sufficiently. So I would agree that something may assist with that.
Thank you. But overall, I think it was a good judgment, well reasoned. Even the conviction was correctly justified.
Yes. Yes.
My second question is on, earlier on when you responded to, was it to the Chief Justice regarding one of your matters which was taken on appeal, on costs?
Yes.
Which matter was that? Is it the Hlazi versus Buffalo City or another one?
No, that wasn't taken on appeal. It was a matter in which I had decided the case on a point in limine, but I deviated from the general rule of costs follow the result, evaluated the facts before me and came to the conclusion that each party pay their own costs. The appellant...
Which is what you did in Hlazi versus Buffalo City as well.
Yes, for different reasons, yes.
For different reasons,
Yes.
Except here you found that while the applicants were successful, they somehow did not apply the rules, notwithstanding the fact that they were litigating against an organ of state.
Yes, that's correct. They didn't apply the rules. There was many things that I was not happy about with that case, Commissioner, with respect. That case, I surprisingly came across in Erasmus, relating to burdening court papers with unnecessary annexures and turning something into a cut and paste situation. I wasn't happy with that because at the end of the day, I know that practitioners run busy lives and cutting and pasting can be the norm. Let me not pretend that that doesn't happen. But if you're going to do it, at least do it properly and do it with circumspection and give credence and authority to the person's case that you're doing. That particular case did not impress me for that reason and for many other reasons, which I think I documented quite extensively in that judgment. And that's why I didn't award the costs to the applicant in that matter.
Thank you, Advocate. I think you deviated, but also you gave reasons why you deviated from the default position.
Yes, I believe, Commissioner, that I evaluated the circumstances as they were before me and made and exercised my discretion accordingly.
DP Zondi is in charge.
Okay.
Thank you.
So I'm a CJ for the time being.
Thank you, temporary CJ.
Any questions, Professor?
Yes, thank you, DP. Good afternoon, Advocate Colette.
Good afternoon, Commissioner.
I must also commend you for the incredible work you have done in the past 40
Thank
years.
you so much, Commissioner.
It's really impressive. Electoral Commission, TRC, Land Claims Court, litigation, etc. My question is based on the GCB's comment. They commend you for your judgment writing, saying you're doing a very good job. You display a good knowledge of law and a consciousness of constitutional law. They go on and on. So I just wanted to ask you if you could share with us your process of judgment writing. What informs that process?
Thank you, Commissioner. When I first receive the case and I read through it, my preparation starts. I've had many years in practice, so it's the same methodology that I would have adopted throughout my 40 years. So when I receive a case, regardless of what it is, I start making notes immediately and I start analyzing what area of law is being covered. Effectively, I start doing the bare bones of my judgment immediately. And by the time I have reached the end of preparing the matter, I have a very good sense as to which way I'm leaning as far as the judgment is concerned. Not that I'm inflexible, because sometimes I've gone to court and I've changed my mind, but I have the bare bones of where I think I should be going. So consequently, I know what I'm listening for when I'm in court. So I know where my areas of concern are long before I've arrived in the trial court. And because I've had experience in a wide range of legal areas, it's not difficult for me to come upon what I would be looking for, depending on which side I was on as a counsel. So like almost like devil's advocate, right? And once I've been in court, I every day, if it's a trial, for example, or if it's an opposed application, I immediately make the notes of those areas where I would have had concern. So my judgment is almost complete before I even go to court in trials. I wait to hear the evidence. I wait to be informed on the things that might be of concern to me, and in fact, may ask questions for clarification on those areas. And then I populate my judgment thereafter as quickly as possible, actually, so that I don't lose the momentum. The momentum is the word I'm looking for. So consequently, and in those circumstances, I'm able to produce judgments very quickly compared to people, perhaps. And that's not because in any way I'm compromising the quality. It's because my preparation and my time management is perhaps operating on a different level to other persons. I've had to time manage extensively during my practice, mindful of the fact that I have had to be a mother to 5 children alongside a practice. Time management has always been very important for me and very crucial in discharging my duties. I don't know if I've answered your question, Commissioner.
You have, thank you. I just wanted to do a follow-up. Do you ever go with a predetermined outcome and then change your mind after the litigants have argued?
Absolutely. Absolutely. In fact, I've done a case just recently. I wrote the judgment and then I was going to hand it down in the week, and then I thought, I just want to go back and write a conflicting judgment, in other words, the other side, and see how I feel. And before I'd got to the end of writing the conflicting judgment, I had decided that I was right the first time around. So yes, absolutely, I'm not inflexible.
Thank you very much. Thank you, DP. Thank you, Prof. Any further questions, colleagues? No? All right. Well, that was the very last question for you, Ms. Collett. Thank you for making yourself available. You're excused.
Thank you so much, CJ. Thank you, Commissioners.
Is your mic on? I can't hear you. Switch on. Is it on? Or
It was not on, yes.
Oh,
Thanks, Chair
that's
CJ.
better.
Good afternoon, CJ, and good afternoon, commissioners.
We do apologize for keeping you waiting. I know you forgive us.
I have forgiven you already, Chief Justice.
Thank you. You have been here before.
That is true,
on
Chief Justice. I think
application
it
for
was
appointment.
2021.
Well, that's what I wanted to verify. 2021, you are applying for a seat in this division, this very division.
Yes, CJ.
All right. Okay. So we do have the transcript, although it's not dated. We do have the transcript, and we have a fairly good idea who you are, and I'm hoping that on the strength of that prior information, we won't be asking you too many questions.
Thank you, CJ.
You hold 3 law degrees.
That is true, CJ.
BUris, LLB, and LLM.
That is true, CJ.
The LLB and LLM obtained while you're already working.
That is correct, CJ.
I see that you joined the Department of Justice as a clerk, a grade 2 clerk, which I did too.
That is true, CJ. It was a grade 2 clerk in 1981 whilst I was at the University of Zululand.
Yeah, and you worked your way up the ladder. You became a public prosecutor, legal assistant.
That is true,
In
CJ.
1984, and then in 1986 became a magistrate.
That is true, CJ.
All right. So the LLB you did whilst you were working as a public prosecutor, not so?
Yes, CJ, I did it when I was working as a public prosecutor in Manfred.
And you were already a senior magistrate when you did the masters.
That is true, CJ.
How did you manage that with all the responsibilities that come with these positions?
CJ, it was an aim that I had of self-improvement, also using my time, sacrificing the time that I have during the night, in order to be able to do that LLM, because I was also attending at times at the university.
In 2013 already, you were appointed as the regional court president, which you still are.
That is true, CJ.
But then you started acting at the High Court even before that. Your first acting stint was in 2011.
That is true, CJ. Judge J.P. Sangoni said, I must not wait for the time when I'm already appointed as a regional court president, because at that time I was acting as the regional court president in Port Elizabeth.
So you've been a regional court president for what, 13 years, and you've acted as a judge since 15 years ago. What did it take you so long to raise your hand for appointment to the senior bench?
Posts were advertised, and I had regional magistrate who had to apply for those posts, and I decided to wait for them. I think it was 4 times when there were regional magistrates who had applied in this commission.
But then you did a lot of good things during that period. There are just too many documents we are finished with by our secretariat. It's difficult to keep track. I don't want to miss anything. I know that you've done a lot, especially during your stint, your tenure in the leadership position, to enhance access to our courts and performance monitoring, and you even collaborated on the preparation of a manual with JP Musi, on judgment writing for magistrates.
That is true, CJ. I have been very much active in the Eastern Cape in the sense that we have a committee that I was chairing, which is called the Lower Court Performance Monitoring Committee. That committee involves a lot of stakeholders, say police, correctional services, DOJ, chief magistrates, as well as legal aid. And in that committee, we deal with the operations of the court at length. And that committee is really more driving the finalization of cases because it solves the bottlenecks like having cash flow blockages, because we phone each other even at night at any time in order to solve the bottlenecks that we have in our courts. I also have been with Judge Musi on the writing of judgment writing handbook, where we were having ideas and putting them down in the writing of the handbook on judgment writing, because even during the training of regional magistrate, I was involved as someone who was teaching judgment writing for the aspirant regional magistrates. And regarding the issue of access to justice, I have also taken a stride in the sense that even before rationalization of the boundaries of the Eastern Cape, taking into account that Eastern Cape is one of the second largest region in South Africa, I was involved in aligning jurisdictions. For example, in places like when I came there, I found that you will find a place like Lady Frey, which is being serviced by Butterworth. And if you look at the distance, Butterworth will have to go through Queenstown in order to service Lady Frey. And I had to stop that because of the fact that I felt that it does not necessarily serve the interests of the people, as well as the state's funds are being wasted if the regional magistrate is going to go to the area of another regional magistrate in order to arrive at the place of work. Same applies when it comes to places like Elliotdale. People there, I had to meet with the people there, the chiefs, and sit down with them that they were telling me that there is a distance of 80 k's from the sea to come to Elliotdale, in places like Tafalofefe, for example. And then those people would have still the task of going to Mthatha, where the regional court was sitting. And I had to abolish that and say, we must establish a regional court in Elliotdale. Same applies, there was no regional court in Flagstaff. I had to develop and have a seat of a regional court in Flagstaff. Same applies in Alwal North. Alwal North was being serviced by the East London Regional Court all the way past Queenstown as well. But that I had to stop and say, Alwal North will have to be done by Queenstown. And in that regard, we had to develop the jurisdiction of Queenstown to include even Stakespruit as well as Alwal North. Stakespruit was being done by Mthatha, and that was a long distance for regional magistrates to go all the way. And I remember when there was DPP who was there, who was saying, how can a regional magistrate go all the way from Mthatha to go and make a postponement in Stakespruit? Now, I had to develop and make a center then of Queenstown to be bigger. That is the way I developed the rationalization of the regional courts for the Eastern Cape, which were fair apart, and giving also other places jurisdiction as well as access to justice, even when there was no such before.
You have enjoyed membership with Nadel, and you have a long-term membership in is it AMSA? And as a judicial leader, you are in the heads of court cluster. And I imagine that you are involved in PEC and more recently in NEC, in the NEC structures.
That is true, CJ. I'm involved in the PEC in the region, and for that matter, we are taking everything that is an issue in the lower court performance monitoring committee and take it to the PEC so that the PEC will be able to solve those problems for us. For example, I think I remember one of those important problems which is done by the PEC is the issue of awaiting trial prisoners who will be in detention for a long period. And when we attend PEC with the JP, we zoom into those cases and then try by all means as stakeholders to see to it that those cases are given first preference, and then we solve all the obstacles which were making those cases to take a long time. And we have made a tremendous progress in that regard. And it is also the same that when we go to the top structure, NEC, because NEC, we also take things which we cannot solve in the PEC and we come them to the NEC. As well, we meet the Chief Justice as the regional court president of all the regions in the South Africa. And then in that regard, we put our problems to the Chief Justice. For example, one of the problems that we have put, I still remember, is the fact that regional courts are inundated with the work in the sense that they are the most courts which deals with the serious crime of the country. And then at times you'll find places like Manfred, where you will have plus minus 900 cases for the cluster coming from all the districts surrounding Manfred. And then those are issues that we solved in the heads of court meeting with the Chief Justice.
The division of the High Court which you want to join is vast, with 4 seats, or more than 4 seats, and there are serious challenges, at least in one or more of its seats. Now, with this vast administrative experience and abilities, which are acknowledged by all the professional law bodies who have commented on your candidature, would you be able to assist the head of that court and indeed me, because things filter up to me when they cannot be solved in the divisions, in resolving some of these challenges?
Thank you, CJ. It is true that our division is one of the biggest. And we also acknowledge that there are 4 seats: Port Elizabeth, Grahamstown, East London, Bishop, and Mthatha. And it is true that through the experience that I had in relation to administration, I ordinarily assist JP. For example, I would quote a good example which has happened recently, where, for example, he would be having somebody who has been appointed in the list, meaning who would be saying, I'm not going to be available for acting. At the last moment, for example, on Friday, I would be able to organize a judge for him, acting judge, that will be available so as to supplement that acting judge who has decided not to be available at that particular time. There are many ways that we act together with the JP, for example, in relation to all the problems we have in the Eastern Cape. Although it is vast, for example, I have been traveling left, right, and center of the Eastern Cape because I want to have control and be able to see the problems and solve the problems which are there in all the areas of the Eastern Cape. And that administrative experience I have for running the Eastern Cape for the past 13 years, I will be able to share with the JP of my region, because we had already started working together and we have a good relationship together. And in as much as it happens with all the stakeholders of the Eastern Cape, there is a cordial relationship of all the courts which are in the Eastern Cape. For example, taking a good example of there being no court for a particular, there being no courtroom available for a court in Butterworth. We do just jettison our regional court and give it to High Court because we want to have cordial relation as well as working together in solving the problems of the region.
All right, let's come closer to the core judicial function. You were a magistrate. I took up a period of 12 years in the district court, and you've been in the regional court since 1998. That's a long time. Now, one would imagine that you've sat as a district court magistrate and as a regional court magistrate. You've sat in all the cases that come before those courts for adjudication.
That is true, CJ. I've been at district court for many years. And in fact, what I normally put as an aggregate, the total of 42 years being a judicial officer makes that I do have extensive experience in all courts. And I have worked in all environments. Courts which were rural, for example, I worked in Manfrey, I worked in Mount Elif, and I also worked in Butterworth whilst I was a district court magistrate. And I've worked in Grahamstown, Port Elizabeth, and all the rural areas around the Eastern Cape, on the western side of the Eastern Cape, so that I remember that time the RCP was Mr. Lukaju, who was saying, I want to expose you to all the parts of the Eastern Cape so that even those parts of the Eastern Cape which are still conservative, you must be there. For example, I was going to places like Jopetina, I was going to places like Colesberg when it still was there, and where you will find that the only language which is spoken is Afrikaans. And fortunately for the fact that I had been having my Afrikaans whilst I was at high school, I was able to communicate and understand the language even better. Therefore, I can say with confidence, CJ, that I can be able to try any case because I've been exposed to all types of cases in my region.
Have you written any judgments as a magistrate?
Have I written?
Actually written judgments.
Even
if they are not reported, we know that.
Yes, I did. I did write judgments, CJ, at that time, and I have written many judgments also as a regional magistrate. I remember that more especially in the district court, some of the judgments were just extempore because of the fact that at that time we were having even cassettes which we were using in court, and the recording was not necessarily as accurate as we have today. But I have written many judgments in all these courts, CJ, sorry.
And as an acting judge?
As an acting judge, CJ, I have also written many judgments. When I was counting, I found that I've written more than 50 judgments in all. And when I was counting them, more than 30, 36 or more could be civil judgments. And 20 judgments are criminal court cases, including reviews. I'm almost having plus minus 50 to 60 judgments that I have written, CJ.
All right. And in your questionnaire, you list the areas of, in addition to the obvious criminal law area,
Yes.
you list a number of cases that you've dealt with in the field of civil law and constitutional law, and well, everything is constitutional. But in other areas of the law, including medical negligence, the whole gamut, personal injury, spoliation, property law, customary law, procedural law, and so on. So I take it that in your time in the High Court, you've sat in all the courts.
I've sat in all the courts. I've been doing duty, CJ, and I remember that this last term, I did duty even 3 times, to the extent that I had to do duty one after another, something which is rare in our region. And I have been also in the appeal court. I've done cases there. I've been in the opposed motion, and I've done criminal cases, trials on criminal cases, and trials on civil cases. And I've done chamber work, and I've done mental patients issues or orders. And I don't think there is anything that I have not done so far. In fact, the experience that I have got in the High Court so far is also plus minus 87 weeks, which I think it is one of the longest for the person to be acting in that period. And when I was calculating it more practically, I could find that that is a period of plus minus 2 years if you exclude the period of recesses. In my view, CJ, I have also done complex cases where you would find that files are going up the wall, and I think I'm really matured and really up to scratch. I can hit the ground running when it comes to issues of being placed permanently in the High Court.
Did you say you are acting now or acted recently?
I've been acting since February 16, CJ, and I have not even been able to get the recess. The recess period also I was acting, and I'm acting now.
All right. I asked because according to your questionnaire, your last stint was in May last year. So
Yes.
you have gone back to the High Court.
Yes, I've gone back to the High Court
And how
since
long
the
is this
beginning of
stint?
this year.
How long, when does this stint end? How long is it going to be?
This stint will be ending on the 29 May, CJ.
All right.
Yes.
All right. Thank you very much, RCP. I'm going to hand over to Acting Judge President Tangulela to put questions to if he has any.
Thank you, CJ.
Thank you, Chief Justice. A good day, Mr. Dunya.
Good day, JP.
You have told us something about courts that you have played a huge role towards their establishment. What has happened to Mkanduli? Mkanduli Magistrates Court that was gutted by fire.
That was what, JP?
Gutted by fire, destroyed by fire.
Yes, fire. It is true, JP, that in Mkanduli, that place was gutted by fire some years back. I think it could be 5 years back. And what was done was to have the mobile courts as well as mobile offices. And since then, that court has been operating under those conditions. And we are told now that it has gone to tender. But it has given us a lot of infrastructural issues, in the sense that you would have an SOS machine there. One day you will find that it has been stolen because that is a prefab where it has been installed. And there are those challenges that are there in operating in a prefab. Thanks, JP.
Yes. It feels in me that the role that you play is more towards, that is as an acting judge, more towards assisting in establishing a single judiciary. Is that a fair comment for me to make?
That is true, JP, because the way we are working together in the Eastern Cape, we work as a single judiciary. What is a problem in High Court is our problem. What is a problem in District and Regional Court is also our problem. We work in such a manner that we have a helping hand towards each other and towards achieving that there must be no disparity between the two levels, the three levels of court. That is how we have the good relationship.
Since you are a magistrate, how far have you gained assistance in the running of civil trials in the High Court? I have in mind your minister, sorry, MEC for health matters that are problematic in the area.
Thank you, JP. Acting in the High Court for myself has helped the region as a whole because almost all the practices that we have seen or that I have seen in High Court, I have come back to Regional Court and implemented them. For example, what has been very much useful in the High Court is the issue of case flow management. Case flow management, which I also learned from Mthatha, starts from the files that you must be looking at as a judicial officer, so that you must be able to assess whether the file is ready for trial and follow it up on issues which have not been done by engaging the parties. That also has been useful for us in Regional Court because of the fact that we have also the amendment of the rules, which now imitate those of the High Court, which now filters all what has been done by the High Court and the experience that we have to filter correctly in the Regional Court. And we are also proud of the fact that some of the judgments that we do in High Court, we come and teach those judicial officers in our meetings of case flow management how to deal with cases of that particular nature. For example, I would go for the issue of unlawful arrest, where you will find that maybe the onus is on the defendant to start. Now, those are issues which we engage the regional magistrates, and then so that they must be able also, when those matters come to Regional Court, they must be able to deal with them. In summary then, we have a lot that I have gained from High Court that I'm practicing when it comes to the Regional Court.
With the vast experience you have in running of trials and administration in the court, especially the Regional Court and the magistracy, what value, in a nutshell, would you add to the High Court if appointed as judge of the Eastern Cape Division?
Thank you, JP. The value I would add in my appointment in High Court would also relate to the fact that as a manager myself and having extensive experience, I'm more interested in finalization of cases. For example, the Eastern Cape is known to be the place where finalization of cases, we are either number 2 or number 3. That is my strength. And for example, even on the issue of statistics, I'm the one who has developed a certain national tool which we use in regional court. And that, in my view, would add value to the High Court, because it is important to see how you manage your cases. And for example, I would go to a good example which I have seen. When you go to Mthatha, for example, you have cases that you are given by a judge and you run trials with those cases. And for example, I saw that I was able to deal with and finalize 2 cases in Mthatha. And when I went down also to Port Elizabeth, I found that there, the practice is that you have your cases that you deal with, more especially with the rough cases, but you have to go to court every day. Even that practice is worthy, because at the end of the day, doing your trials, you want to finalize that case immediately. In my view then, the value that I would add in High Court is to see to it that at least cases must be finalized as soon as possible, as well as also to develop a tool which will also inform the manager as to how the work has been done in his or her region.
Thank you, CG. So those are my questions. Thank you very much, CG.
Thank you very much, CJ. A good day, Mr. Dunywa.
Good day, Premier of our province.
Well, CJ, I'm largely covered. I really don't want to delay the JSC. I think Mr. Dunywa has almost answered almost all my questions from the transformation point of view. I must just appreciate the robustness and the hands-on approach, also the appreciation you have on the reputational damage that we sometimes suffer from as the province. So I think the work you have done, also answering the rationalization, it looks like you did it before, even the report by Justice Musenege. You were already on the ground, hitting the ground running. So I think, let me just appreciate that. Thank you very much.
Thank you very much, Premier.
JP Tlalezi.
Thank you, Chief Justice. Good day, Mr. Noir.
Good day, JP of Limpopo.
Yeah. I was appointed to the SCA the other day. Now you are transferring me to Limpopo. Thank you.
I'm sorry for that, JP.
Yes. No, we do meet a lot at heads of court meetings.
Yes.
Yeah, I just want to cover 2 aspects with you relating to your application. But by the way, how many years do you still have to go to compulsory retirement in the public service?
For the regional court one, which is 70, I still have 7 years to go.
7 years.
Yes, JP.
Yes. Now, the GCB has indicated in their comments that under the heading, your knowledge of the law, including constitutional law, and they say regarding the judgments you have referred them to, they cannot state positively that you have the requisite knowledge of the law, including constitutional law, to be appointed as a permanent judge. Would you want to comment on that?
I do understand that. Should I say Judge of Appeal or JP now?
To the High Court. Oh, you mean me?
Yes.
Commissioner.
Oh, fine. Thanks, Commissioner. I do understand that the issue that can be making them not to be able to comment positively is the fact that the the number of judgments that I have submitted, for example, may be not enough to deal with some of the issues for them to be able to be positive about that. For example, I think it's only one review that I still remember, which was dealing with the constitutional issues. The one which was dealing with Section 35(3), that relates also to the right to be tried in the language of your choice. I'm sorry, in the language in which you understand. That is the one where constitutional issues were mentioned. Most of the judgments that I've given dealing with procedural law, I remember the one on special plea, as well the one on execution, as well as the one on criminal cases. Specifically, I have not submitted all, or no one can be able to have a perspective of one's career without necessarily having his work and perspective of his work together.
Is the short answer that you agree with them?
I agree in the sense that on the basis of the judgments, they cannot be able to do so. But
Yes.
in my view, I'm very versed with the Constitution. In fact, I was also the person who attended the human rights, which was dealing with the Constitution in Pretoria as well as in Sweden. Therefore, I know much about the Constitution. I don't doubt about that.
Sorry to interrupt you. I'm just saying what they say, what they've got, they are unable. Do you agree with that?
I agree with that because that is the information which they had at hand.
And then they say on the extent and breadth of the candidate's professional experience, they say they made a mistake to say the candidates, but they want to say the judgments referred to by the candidate do not allow for a comprehensive assessment of the breadth and extent of his experience to be undertaken. What will be your comment to that be?
Even in that regard, Commissioner, my view is that it depends on the type of judgments which has been brought before them. They cannot deal with something which is not before them.
Okay.
Yes.
And then they say the candidate's linguistic and communication skills, nothing in the judgments and other writings considered by the reviewers indicates that the candidate's linguistic and communication skills are not adequate. There is positive.
Are they not?
They cannot say they are not adequate.
If they say they cannot say it is not adequate.
Yes.
I think that is also dealing with the issue that it depends on what they have before them. The judgment that I wrote would also not necessarily be written by me alone. I would also send it to a researcher, even for proofreading for that matter.
Yes. And then on the judgments that you have attached, the one FinCorp Trading, 113cc and Standard Bank, that one deals with the stay of a warrant of execution.
That is true.
That will be a run-of-the-mill case.
That is true. I agree.
And the other one is a bail application in the High Court.
That is true.
And then your very first sentence, a second sentence, you say the applicants did not apply for bail at the appropriate forum, being the district court. Any reason why you had to entertain this bail when it's not an appropriate forum at the High Court?
No, I meant, Commissioner, that the appropriate forum for dealing with bail is the district court.
Yes.
And it is for that reason that they must deal with all the bail, because when you come to another forum, regional court as well as the High Court, they are courts of trial. They are trial courts. Therefore, to have your time wasted by doing something which could have been done somewhere else is also not fair in the circumstances.
So in this case, the High Court judge time was wasted and the resources.
Yes, because that time could have been used in trying cases and finalizing them, JP,
And
Commissioner.
And this case was not pending in the High Court at all.
It was not?
Pending in the High Court. The accused had just been arrested and they were to appear in the district court. Or is there anything that is additional that's missing?
I don't know which case we are
The very
dealing with,
same one of bail,
JP.
the very same one of bail. The name is A. Kochiana and one other versus the state.
I cannot remember now, Commissioner, because the bail appeal, it means the bail has been heard somewhere.
Yeah, but in your judgment here, you say this is a bail application that was brought for the first time in the High Court. So it's not a bail appeal. I don't know if you understand, follow what I'm saying.
Maybe let me check Kochiana then.
Yes, but this is your judgment that I'm reading. I won't mislead you. If that is the
Yes,
case, I
no,
can
I
apologize
understand.
thereof. Yes,
I understand.
yeah. And the other matter that you are tasked is a special review in terms of the Criminal Procedure Act.
Which paragraph are we at?
Okay. If you want me to take you back to that case, it will be the very first paragraph of Kochiana matter.
Chief Justice, it's at page 35 of the paginated papers, or page 39 of the electronic transcripts.
Thank you, Commissioner.
No, I think, Commissioner, the issue that I was emphasizing in that one was the fact that I found it. It was not a bail appeal.
Yes.
It was an application for bail which was brought for the first time in High Court. Yes, that is true.
Yes. Okay. And then the
Chief Justice,
last.
may I just follow up on this, if I'm not going to disturb the flow of the JP?
Okay, you may continue.
Can I just do that? On this aspect, your opening sentence suggested that you did not have jurisdiction.
No, that is not what I meant. Jurisdiction, all courts have jurisdiction. Even the regional court has a jurisdiction if that bail has been raised in that particular forum.
So you were convinced that you had jurisdiction?
I had full jurisdiction. That is true.
So it was not a wrong forum?
No. It was not an issue that, but my point which I had raised here and which I still agree to, the forum of bail is the district court where the preparation for the trial must be done.
So they were correctly before you?
They were correctly before me in the sense that the accused had applied for bail at that particular time when the matter was before High Court.
But the case itself was not before the High Court. They just brought a bail application at the High Court. The matter was not pending at the High Court.
No. That is the understanding that I had, that the matter was before High Court, that one. That is why I had to deal with that bail, because the other court would be dealing with the trial.
If you say matter, you say in the application itself or the case, the criminal case for which they were arrested?
Or fine, maybe let me explain it this way. Normally cases would go to district court and then transfer to regional court or to High Court. Then if the accused raises the issue of bail whilst he is in the new forum, meaning the High Court or the regional court, the case is not taken back to the district court to be done. It is done by the forum where the accused appears.
Yes.
And that is in accordance with the judgments that we have in this regard.
Yes, but
Yes.
in this case, the criminal case were in the district court. It was not transferred to either to the High Court where you were sitting now as an AJ, acting judge.
Where do you get that, Commissioner? Because I don't have that information here.
Well, I get it from your judgment, but let's not let it not be an issue. At least we have explained the principle. I agree with the principle that you are espousing. And then the third judgment that you have attached, or the last one, deals with just an ordinary criminal appeal.
That is true.
Yes. So
Commissioner.
in a nutshell, you are saying, is it correct to say you have done yourself an injustice by not attaching to your application sufficient information to be able to assess you whether you are fit and proper to be appointed to the High Court?
Well, in my view, Commissioner, that is not the case, but because the issue of submitting judgments, I did not understand it to be meaning that you must submit judgments which are showing your insight in a particular way. I was submitting judgments of cases which I have done and which I had properly done. Hence, those cases, even the law bodies do not necessarily say I decided wrongly. And I have seen the advocates for transformation commending my style of writing those judgments, all of them. I don't see the reason why we can be saying I should have submitted maybe other judgments where maybe I've dealt with certain issues. Because, for example, even the judgment which was dealing with COIDA, I think it was dealing with something different and which necessarily showed that that is how I approach the issues. And in fact, even the bodies, law bodies, have commended those judgments.
So the onus is on this body, the JSC, to go and research your work to come to a conclusion that you are fit and proper, not necessarily rely on what you have presented as your work, your judicial work.
My judicial work, Commissioner, is reflected in the judgments that I've submitted and is also reflected in the work that I have done, because not only these judgments are the judgments that I have done, and there is no serious issue about the judgments that I have done, and I have done my work in doing those trials efficiently.
Thank you, CJ.
DP Sond?
Hi, good afternoon, Mr. Dunywa. It's Commissioner Zondi.
Thanks, Commissioner.
Yeah. I've got just one question to you, and it relates to the judgment that you attached. And my brother, Alicia, has referred you to it. It's Fine Corp Trading versus Standard Bank.
Yes.
It's a matter that concerns the suspension of the writ of execution.
Yes.
In that judgment, you correctly set out the legal principles which are applicable. But I'm not sure of the basis on which you refused the application. In other words, I can't see how you apply the applicable legal principles to the facts of the case that was before you. The basis upon which you dismiss the application, it's not clear, or there's something that is lacking.
Thank you, Commissioner. I think the reasoning behind that judgment appears clearly in the latter parts of the judgment, more especially when you consider the judgments of the of Hoyce versus Shakespeare, sorry, Shakespeare versus Van Zyl, which is the judgment of the Labor Court, which was dealing with the issue that execution the grant of stay of execution where real and substantial justice requires, it can be granted. I think I've listed 4 of the items that must be satisfied in terms of that judgment. And the main issue which I was dealing with them, we were dealing with the issue of the fact that I must deal with pity versus the law. Because the issue which was there in that case was the issue of the applicant saying, can I have the execution stayed? Whereas the other party had been owed money for 14 months. Now, the execution has come, and it has not come because there was an irregularity. It was there because there was law. And the issue which was raised by the applicant was that when it comes to the fact that we must have pity for him because of the fact that if execution is done, he would lose the company and the employees will be retrenched. And therefore, we were dealing with the pity. I think the pity issue has been also addressed as a form of what we call let me quote it correctly. But it says the main purpose for that is that one must be having a pity and mercy for the person because of the fact that he is going to lose the company, as well as have to retrench the workers. And that was based on a hope that maybe after a period of 5 weeks, he may be having money that he would be using in order to pay the debt. Now, I think I have addressed the issue there clearly, that there is no need, if the banks, like any other person, we have equal rights. Therefore, there was no need for the bank to wait for the person to find money in order to have execution done for them. And more so, the fact that the period where it has been waiting was 14 months, and there is case law also to the effect that there must be finality in each and everything that you do. Therefore, I relied on that authority, on those authorities, that what is important is that execution should not be stayed, but instead, let's have the execution operating.
All right, thank you, Mr. Tunja, but yeah, I don't have a problem with the manner in which you set out the legal principle. Where I do have a problem is the application of the principle that on which you rely, how you apply them to the facts of this particular case. That's what the problem is. It wasn't clear to me on what basis you dismissed the application after having referred to those legal principles that set up in the cases that you have cited. All right, thank you, Mr. Tunja.
Thank you very much, Commissioner.
Commissioner Kane?
Thank you, Chief Justice. Good afternoon, sir. I want to refer to the transcript of when you last came to this commission during 2022. And I don't know if you have it before you. I can summarize what happened in an exchange between you and the judge president at that time. He referred to the fact that you had done 7 matters in the High Court during your acting period, and only 2 of them were civil matters. Then he spoke about a meeting that you had with him where you had discussed that civil cases are largely referred to the High Court in your jurisdiction, even though the regional court would have jurisdiction. And you agreed that was true. And you agreed with the JP that the regional magistrates don't necessarily have the same experience as the High Court when it comes to civil work. And then the JP said to you that there was an important reason for acting in the High Court, which was that you would emulate the work ethic there and then take it back to the regional court, which you've also spoken of today. And you spoke about the exchange of training. In other words, the JP could send you people who needed more experience in criminal law because you had that expertise. And he referred to the fact that in the High Court, the challenge is the civil jurisdiction because it's much wider and requires expertise in civil trials. And you agreed with all of that. And you then said that it was intended that you should gain more civil exposure because you already had the criminal exposure. Now, in light of that, the issues that have been raised with you by my fellow commissioners is really that you have placed before us a handful of judgments that predominantly deal, again, with issues in criminally related matters. And so isn't the GCB correct that you just haven't given us material that would identify that you have overcome this difficulty that was identified when you last interviewed? Namely that on the criminal front, there's no doubt you're well qualified, but that more is required for us to appoint you to the High Court.
Thank you very much, Commissioner. Transcript of the last interview. It is true that regional magistrates started to do civil work from 2010. Before 2010, regional court was not dealing with civil at all. They were dealing with criminal court work. The reason for me to agree then to JP's viewpoint was that the experience in civil for regional magistrates was based on the cases that they have done as far back as 2010. Coming to the issue of exchanging people between regional court and the High Court, it is a fact that we do that exchange, and but many regional magistrates have now gathered civil, and they do understand civil work clearly. And further, if I was to also deal with that issue raised by JP, JP was raising the issue of civil, which was relating to his time. I have worked not only during his time, I've worked even during Judge Sangoni's time, from 2011, 2014, 2016, 2018, and 2020. Now, the issue was relating to the period only when JP was himself the JP of the Eastern Cape. And that is why then I also explained that when you take into consideration the period when I acted, it must not be forgotten that I started as far back as 2011. And furthermore, when it comes to myself then, I have not, he talked about the issue of mileage. Well, I think that issue of mileage was issued, directed mainly during his time. But the mileage of the time when I was acting under Judge J.P. Sangoni was not necessarily added. And furthermore, since my last period of being here in the JSC, I have been acting judge for all the years, from 2021, 2023, 2022, 2023, 2024, 25, up to 2026. And I've been doing civil. And I have increased that mileage, whether it would be needed from whatever angle. I don't know whether there is part of the the question that I did not answer.
No, thank you. I've noted that answer. Perhaps then, in all the periods that you did act subsequently, it would have been helpful if you'd given us reported judgments in the civil area from which we could have assessed a marked difference in your experience from the last time you were interviewed.
That never came to my mind, because what was required was the issue of judgments. For example, I think one of the judgments, the one of the one of East London, the one of Koida, was after the interviews, if I think, unless I'm making a mistake, but I think it was after the interviews. But my thinking was not necessarily that judgments to be handed over to the JSC should be judgments after the interview. I didn't think like that.
Thank you, CJ.
Commissioner Nkonyane.
Thank you, CJ. Mr. Tunya, still morning or good afternoon.
Thank you, Chief Commissioner, who is the chief.
Yeah, thank you so much. You and I have been magistrates together for some time, some years ago. And I don't know whether I did appear to you before you as a counsel there. But my question are two. One is a follow-up from the fellow commissioners. I know there has been a judgment that you delivered in respect of dispute in traditional leadership, for instance. But when you submitted this, I found that you did not bring that judgment here. Is there any reason why you restricted yourself to criminal and civil?
Thank you very much, Chair Commissioner. And thank you very much also to refer that to that judgment of Makosini, where we dealt with the traditional leadership of Mizizi. And it was a complicated matter. And it is a matter where we also we reviewed the administrative act of the commission, as well as the MEC, as well as the premier then at that particular time. And as a result of that review, the court found that there were irregularities which led to the fact that the administrative act, which was in terms of PAJA, had to be set aside. I agree, Commissioner, that I did not put that case, not for any specific reason, because that judgment was not even appealed. And, but it could have been an oversight on my side, but I agree with you that that judgment needed knowledge on PAJA. It also needed knowledge on customary law and traditional leadership. But I have no specific reason why I have not put it, Commissioner. Thank you for reminding me about it.
Yeah, thank you very much. The last one, in terms of administration, particularly in terms of transformation of the regional court, it's commendable. And now, should you be successful, would there be anybody that would be there leading the magistracy in the province to continue with the ring challenge of transforming that sector of the judiciary?
Thank you very much, Commissioner. Maybe let me start from where you have started as well. It is true that I have done a lot also in relation to transformation. For example, the Regional Court of the Eastern Cape, I think it is the only one where there are 20 females as against 18 males. in the whole region, the permanent regional magistrate, as currently, as we speak now. And it is true that there are many things that we have done also as Eastern Cape in order to advance the issues of transformation, and even in terms of the numbers, Africans, there are more Africans in the regional court of the Eastern Cape, just in line with the statistics of the population of this region. And I agree that even when one is in High Court, if appointed, there will be people who will be advancing the good things that we have been doing in the Eastern Cape, because I've been exposing most of the senior magistrates in the regional court, for example, what we call coordinators, because the way I decided to rule or to deal with the administration of the Eastern Cape, I appointed coordinators for each and every center. For example, there's a coordinator in Mthatha, coordinator in East London, Zulisha, Port Elizabeth. Therefore, those people, I have exposed them to be RCP in my absence, and I'm of the view that the caliber of the people that we have in the region are such that they can take over. They can deal with all the issues of the Eastern Cape, considering the leadership I have exposed them in. Because I was the type of a leader who was not necessarily, who was leading by example. For example, if there is an issue, say the magistrate is not present in a particular place, I take my gown and be in that particular court. I also involve myself in the number of finalized cases that we have done. Therefore, I was not leading behind.
Thank you, CJ.
Minister? No, I'm fine. Thank you, Minister. Commissioner Mangen?
Thank you, CJ. Yes, you dealt with one part because just the last part where you say that you don't lead from behind, because I was concerned that in your questionnaire, you did say that you appear in the regional court occasionally. And I noted that you did not have any part-head and or reserved judgments from the regional court. So I was actually surprised that how was it like that? It appeared you were just allocating matters to other people and not working yourself. But I'm happy with your answer. The question that I have for you, I must say at the outset that I share the concerns that the DP raised with you on the Standard Bank matter, where you dealt with the stay of the execution. As I read the judgment, I get an impression that amongst the reason why the applicant wanted to stay the execution was because she wanted to explore business rescue. Well, and we all know, and that what purpose business rescue serve. But also, it appears from the judgment that the applicant was saying that there were existing contracts, running contracts with the municipality, suggesting that, one, she was willing to cede those contracts to the creditor, but as an alternative to her being afforded an opportunity to liquidate the debt. And in your judgment, it's not really very clear why those could not be considered as justifiable basis to grant the stay.
Thank you, Commissioner. In my view, I think I have covered many things in my judgment, because I was not necessarily even thumb-sucking the reasons why I refused the stay. For example, I have referred, if you check in paragraph 24, I have referred to the Huys takes Shakespeare pub versus Van Zyl, where the principles should be followed, which would necessitate one to grant the stay. I also have referred to the decision of Stoffberg and another versus Capital, where it was, I think it was Binswat J, who said that if one is dealing with the stay of execution, it should be granted, on a mere plea of misericordiam, meaning you can't grant the judgment on the feeling that you are feeling pity for a particular individual. For example, in this case, you have issued summons. You have defended the action if you can. You have the judgment that is saying you are owing pay. And then at the end, it is the execution. Now, at the end, you say, no. I think I have money which may come, which you are not even certain that it may come. And it has taken 14 months that you have not paid the debt. And then you say, please have pity on me, delay this execution so that I can be able to find money anywhere that I can find and then be able to pay. That is what the courts that I have quoted there say. You cannot do it because you can only grant the stay of execution only if the interests of justice demand. There is no such thing which has been shown in this particular case that there is interest of justice which demand that. That is why then this court decided to follow the decision also of PP Southern Africa, which has also been quoted, as well as the other decision also of member of Executive Council of Finance. All they are supporting the view that the finality must be reached. If execution is to be done, execute, so that the case must be finalized and we are done with it. But you cannot, at the end of the day, say, let's wait for something that you think you may be able to save yourself. That is the reasoning behind the judgment.
I wouldn't want to exploit further. I'll let it rest here.
Thank you. Professor Mango.
Thank you, DP. Good afternoon, Mr. Tunya.
Afternoon, Commissioner.
Just for clarity, from the conversation you had with Commissioner Kaletsi, and also you also mentioned Paja when you were asked a question by Commissioner Nongonyan. Can you confirm that you have knowledge of constitutional law and that you have dealt with constitutional law in your judgment?
Commissioner, I have not done with the constitutional invalidity of an act of parliament, for example. That is the only part that I have not done.
But you have dealt with constitution.
I have dealt with the constitution left, right, and center.
Okay. Thank you. And then just to make you shine, I've been asking this question to everyone. Could you please take us through your judgment writing process and what informs you in that process?
You mean I must deal with judgment writing as a process?
Yes. What do you do when you are writing a judgment? What is your process? Briefly.
Oh, fine. The judgment writing is informed by what we call ifilaro. Ifilaro means there must be introduction of the judgment, there must be facts, there must be issues raised, and then there must be law, and then there must be ruling or order given. Meaning, your judgment must be styled in that particular way. And that is the universal way all courts' judgment are done, universally, meaning all over the world, generally. And then your judgment must have the introduction then, and your facts must be concise and simple, using summarizing the facts briefly, and then you go to your issues. You must tell the reader that the issue in this matter is this and that. And then you must tell the person reading what is the law before you, and then you must be able to make a ruling then whether you agree with either the applicant or whether you agree with the respondent, if it is an application, as well as plaintiff or defendant if it is just a normal action. And then you make your order, and that is your final one.
Thank you, Mr. Dunya. Just to tell you that the GCB commends you on your judgment writing, that they are clear and structured. Thank you. And thank you, CJ.
Thank you very much, Commissioner.
Commissioner Poso, Lerotoy.
Thank you, CJ. Good afternoon, Mr. Dunya.
Afternoon, Commissioner.
Yes, just to confirm that you stated that the law bodies had commended you on your judgment writing. I just want to take you to just some of the comments made by AFT, for example. If we go to the judgment relating to fine corp trading, which has already been discussed extensively, I won't go into the facts, I'll just read the comment made by F. The judgment reflects a coherent and principled application of the distinction between legal execution and injustice. The candidate's treatment of the applicant's equitable arguments demonstrates an ability to extend genuine sympathy to a commercial victim of the pandemic, while nonetheless upholding the structural legitimacy of judgment enforcement. That is one of the judgments. The second one is Katz Group versus business. Similarly, there is a comment that you demonstrate the ability to recognize constitutional factors and constitutional rights of parties. The next one is Mkhange versus Gcelishe. Similarly, there are comments that the judgment reflects an appreciation of the balance between freedom of expression and the right to reputation. The candidate's insistence on the temporal requirements for urgency and the prospective nature of interdictory relief provides a workable framework for social media defamation cases. Just to save time, I won't go through many. However, in most of these judgments, as far as AFT is concerned anyway, it is clear that you are able to interpret and analyze constitutional values when in your judgment. My only concern, however, is that you said you wrote 50 judgments. Is that correct?
Yes, Commissioner, I said so. Including criminal reviews as well as civil judgments.
From 2011
Yes,
to 2026.
Commissioner. Yes, Commissioner.
You wrote 50 judgments.
Yes, Commissioner, those were the judgments that I was able to find in my laptop. I don't necessarily say they are limited to that, but those are the judgments when I was checking my laptop. Bear in mind that laptops are changing and some of the information is not necessarily kept in the laptop. But those are the judgments I was able to find in my laptop when I was really checking individual judgments.
Thank you. And now the question I've asked every other candidate, are you aware that there is the anti-sexual harassment policy?
I know the anti-harassment policy, sexual harassment policy. That is the policy that we were given by Chief Justice as heads of regional courts. And regional court was the first institution to sit down and analyze and make the recommendation which was supposed to be sent to the Chief Justice. The regional courts were the first people to have a meeting and discuss the sexual harassment policy.
Now you say the recommendations were supposed to be sent. Were they sent? Were they in fact sent to the Chief Justice?
We were the only institution which sent them first to the Chief Justice. In summary, we sat and analyzed and checked everything what is required of the head of court to do in relation to the sexual harassment policy. Because there are certain duties which are given to the head of that particular division or that particular court, that he must see to it that the sexual harassment policy has been taken to all individuals who are under his control. And for example, you cannot have somebody acting under you without that person having been given a copy of that sexual harassment policy, because it is not only applicable to him, it also applies to the staff members who are being served by that individual. Therefore, it is important that every information must be given to all the regional magistrates, judges, and whomsoever, so that they should know their limits when it comes to issues of relating to sexual harassment.
Thank you very much. I must give you 10 out of 10 for that response.
Thank you very much, Commissioner.
Thank you, CJ.
Thanks, Commissioner. 10 out of 10 indeed. Not only did the regional magistrates, jump to scrutinize the policy, they fully embraced it, they poked holes in it, they made suggestions and embraced it. And we're very keen to know when it would be implemented and asking about webinars and all sorts of things. So proud of you.
Thank you, Chief Justice. Thank you very much.
Any further questions, commissioners? All right, that's the end of your interview, Regional Court President Tunyo. Thanks for making the time.
Thank you very much.
You want to raise with us? Otherwise, you're excused.
No, I want to say thank you very much, Chief Justice, as well as the commissioners, for giving me this opportunity of coming here to be interviewed. I also thank the staff of OCJ for making our method of coming to this place very smooth and with dignity. And lastly, I also want to thank also the law bodies for their support to us as candidates in this interview.
You're welcome. You are
Thank you.
excused.
Thank you, CJ.
Commissioners, I propose that we take a 30-minute lunch adjournment. But before we do that, there is an urgent matter, or a matter that needs our very urgent attention that has come up that we need to discuss before we eat. So I'm going to ask that the room is cleared quickly. We are running way behind schedule. Clear the room quickly so that we can have a discussion.